Good morning, everyone.
Listen. Okay.
We're all set?
Yep.
Good morning again, everyone. If we could take a minute and go around and introduce ourselves, if you'd like to start.
Good morning, everybody. Happy New Year. Matthew McIntyre, representative for House District 18. And apologies, I have to jump over to the UT already this morning for work session, so I'll stay here for a little bit
Okay,
and then fairly well.
thank you.
Good morning, everybody. Happy New Year. My name is Mana and I represent part of Lewiston.
Morning, my name is Grayson Lochner. I represent House District 113, which is part of Portland.
Good morning. I'm Representative Bob Nutting. I live in Oakland. I represent the towns of Oakland, Smithfield, Mercer, Starks, and a portion of Sydney.
Morning, Tavis Rock, Hassenfuss, House District 57. I'm the House Chair of this committee.
Representative Odell?
Certainly. Good morning. My name is Donnie Ardell. I represent House District 6, which is a series of towns and communities in central and southern Aroostook County.
Good morning. I'm Representative Steve Bunker, District 75, which is Farmington and Chesterville.
Good morning, everyone. I'm Representative Michael LaJoy. I represent District 96, which is part of Lewiston.
Good morning, everyone. Nina Milliken, House District 16, Blue Hill, Brooksville, Castine, Sedgwick, Surrey, and Trenton.
Good morning. I'm glad people are here. My name is Penny Beebe Center. I'm the senator from Knox County, which is all the towns except for Idaho and Washington. And Will, would you like to introduce yourself?
Yes, absolutely. Thank you, Madam Chair. My name is Will Tu, and I'm the legislative analyst for the CJPS committee. And this morning we have a couple of items on the agenda. We're just going to start with an overview from this paper with a letterhead memo to the committee, just kind of going over what we have planned for this session and what you can expect going forward. I expect that to last around 30 minutes. Then we'll have the Department of Corrections here this morning with us, giving a briefing on some of the recent escapes at the Long Creek Youth Development Center. And then around 11 o'clock, we have the Department of Public Safety here. I think Representative Hassenfuss has talked to some of you about this, but initially the plan was to talk about the department's abilities for oversight and disciplinary actions for law enforcement officers. That was part one. And then part two was going to be related to the Capitol Police is merging or transitioning with the Maine State Police. That was initially planned for today, but I think there have been some new items that it might be more pertinent to deal with later in the session. So that is going to be scratched from today's, and they're just going to be focusing on the law enforcement officer disciplinary and overview today instead.
Isn't it technically going to become a bill?
So we don't know at this time.
Okay.
My understanding, I think Representative Hassenfuss might have more information on.
Yes, I have been told that there will be a governor's bill coming to us that deals with that specific topic.
Yeah.
What place numbers?
No, with that, there will be a governor's bill that comes to us dealing with the transition from Capitol Police to State Police.
Yeah. Okay. So starting just with the overview here, as you all know, the legislature convenes tomorrow. We were granted authorization to meet early today to start working on some of our carryover bills, which ironically we won't be doing today, but you'll find out why later. As you know, we have a brief session. The statutory adjournment date is April 15th. So we've got around 2 months less of time to work with. Thankfully, we have much fewer bills this time around, but including carryover bills from our first regular session, newly introduced legislator bills, new agency bills, and then any potential committee bills that are produced from the reports that either we passed in the first regular session or perhaps 2-year reports that were passed during the 131st legislature. We may have additional committee bills spawn from those. So this is just a rough estimate, but I anticipate we'll have approximately, combining all 4 of those categories, around 40 to 50 bills to consider during the second regular session. And I think we have around 13 weeks to do so. Just for comparison, I think last session we ended somewhere around 125 bills. So significantly less than that 40 to 45 range is really, I'm expecting worst case scenario. That's not going to be our entire work, as you know, is not just working on bills. We'll have other issues to deal with, have the supplemental budget at some point in the session, but this is really just focused on what substantive work in terms of bills we'll have going forward. The committee's authorized meeting days are Mondays, Wednesdays, and Fridays. That's the same as it was in the first regular session. If you'll recall, we were meeting on Thursdays. That was only because we had requested permission to meet on Thursdays from the presiding officers. Now that we're going into a new session, that permission, those authorized days are gone. So if we do want to meet any other days outside of Monday and Wednesday, Friday, we're going to have to request those days. Again, in terms of our workload, I think I would be surprised if we would need to do that. But knock on wood. So we'll see. So moving forward, I think we should anticipate that we'll meet every Monday and Wednesday. I don't think we met any Fridays last session, and I don't anticipate that we will need to. Yep. So additional days might be added or removed depending on the requirements. And then pursuant to the current session schedules, I believe it's been sent out to all of you. I think essentially the rough goal right now is every month, one day is being added in the chambers. So right now, I think you guys are meeting Tuesdays, tomorrow being an exception since you're reconvening. So I don't think there'll be any overlaps. Last session, once Wednesdays were added to the calendars, we kind of lost those mornings, and that's part of the reason we added Thursdays. I don't recall I don't think you guys are meeting until March, or Wednesdays won't be added until March. So we'll have quite a while to where the chamber sessions won't overlap with our committee work, which I think will be really nice. So let's talk about the first category, carryover bills, which is what we've kind of been directed to focus on the most. So as I said, we were referred approximately 123 bills last session, and we voted out 108 of them. 15 were carried over to the second regular session. Pursuant to the July 8th, 2025 memo, the presiding officers directed the committees to report its carryover bills out of committee by January 30th. So accordingly, the committee is going to spend most of its time focusing on carryovers in January, and then we'll move on to newly introduced legislator bills and agency bills. This is a list of those carryovers, just for a refresher. I'm not going to go through every single one of them, but I do want to just point out a couple of things. On the second page, you'll see the top one, LD 755. So this was an act to prevent opioid overdose deaths by allowing municipalities to approve the establishment of overdose prevention centers. That has been requested to be withdrawn by the sponsor. So that is currently in process. It's not withdrawn at this point, but we are in the process, right, of getting that withdrawn. So that bill won't come before the committee this session. Just so you know, in case you were wondering where the bill went. Conversely, so we lost one bill, but we gained one bill in a way through LD 882. If you'll remember, this is a bill we already held a public hearing on and a work session. This was an act to protect communication with providers of critical incident stress management peer support. This was Representative Salisbury's bill. That was a unanimous report that came out of this committee, as ought to pass as amended. There were some FOA components of the bill, so we were required to go to the Judiciary Committee for a review. They had found some issues with the bill, which were amended through language review. I know it was a long time ago in June. There was a reporting component of the bill that was removed that was re-added in language review, but Judiciary pointed out some other issues with the bill, and ultimately that was pulled back to committee. So we won't get too much into the bill, the shortcomings of it, or what we need to address, because it's not scheduled for today's work session, or it's not scheduled for a work session today. But just know when that gets reconsidered, wondering, we dealt with this before, why is it coming back to us?
And which bill is this?
LD 882, it's the one that's,
882.
yeah, the underlined one.
Okay.
And I'll explain that in further detail when we bring that up for a work session as to why it stayed in committee. Yeah.
Other than that, I won't point out anything too particular in the remaining bill list other than this series of bills, LD 1916 through 1919. We have public hearings on those scheduled for next Monday. That was a committee bill from the Judiciary Committee, and near the end of the first regular session, that was transferred over to us. I think on the floor, saying that it was probably more under our jurisdiction. So they received the presentation and created the bills out of the committee, but they were transferred over to us. So that'll be next Monday, and I'm going to send you guys an email about that report. So keep an eye out for that email. Last, we have 3 carryovers. So these are both placeholders from the chairs that we were allowed to carry over. being carryover placeholders. They have no language in them. They're simply for emergent issues or things that the chairs would like to address. The presiding officer's memo indicated that I think public hearings need to be held prior to January 30th on those. We can request permission for public hearings to be held for them after January 30th. But ideally, if there's something that we would like to use this for, we'll try to address those as well before the end of January. So that contains carryover bills. Any questions regarding our carryover bills? Any issues there? Okay. So we have newly introduced legislator and agency bills. Once we've addressed a majority of our carryover bills, the committee will shift its focus to the newly introduced bills from legislators and agencies. The Legislative Council approved 5 new legislative requests that are currently indexed to the CJPS committee. That doesn't necessarily mean that they will come to CJPS, but there's a good chance that they will. In addition, approximately 12 legislative requests from agencies and departments are expected to be referred to CJPS as well. Both figures may fluctuate depending on where the bills are ultimately referred. So you have the legislator bills there. Again, I won't go through all of them. It's just for your reference to see what we'll likely be dealing with, addressing in February. So a quick note on that, on the carryovers, like I said, we will be trying to address them this month. Not everybody's here today, so having public hearings on a lot of the carryovers is a little difficult with so few legislators here today. So today's a little bit of an exception. We are not hearing any carryover bills. In fact, we have 2 new agency bills that we'll be hearing today, but those are just an exception to what we're going to be trying to do this month. So last, we have reports containing legislative authority. We'll receive several reports based on resolves, like I mentioned earlier, that were passed either in the 131st or in the first regular session of the 132nd legislature. Each of these reports include authority for the committee to submit legislation based on the report. It's not an exhaustive list of all reports that we receive. These are largely ones that contain authority to submit legislation. And so it's focused more on first-time reports received by the committee that have authority to submit legislation. Committee members should note that there are also reports in which multiple legislative committees are authorized to submit legislation. So it's not necessarily the case that every single one of these reports will result in us reporting out a bill. There are some instances where we report out a bill or we receive a presentation, we have a resolve, and we think transportation might like to hear this, housing and economic development might like to hear it, but it's more a courtesy, so they are kept in the loop, and then CJPS or whatever committee is ultimately going to actually refer out a bill. So in total, there's approximately 11 one-time reports that the committee will receive during the second regular session. Many of these reports have not yet been received by the committee, but they'll be made electronically available as soon as possible upon receipt. And then physical copies of the reports will be distributed to the committee, assuming there's one provided by the reporting body. The remaining pages are just a list of these one-time reports. You'll remember most of these since a lot of them spawned from the first regular session, so we would have just voted these. The only ones I'll note in terms of reports received, the missing persons, DPS did send us an interim report. They said that they still need a little bit more time, but they are working on it. So we'll keep up to date with them in terms of what the final product is. The fire sprinkler system reviews, we did receive that report. The fire marshal will be here today giving a presentation on that, and he has physical copies for the committee as well. So we received that and we'll be addressing it today. Next page, we have the oral fluid testing. I believe that was Senator Searway's bill. We have received the report on that, and that has been distributed to members electronically over email. We don't have physical copies yet, and nothing scheduled yet for that, but we'll probably also try to weave in some presentations throughout January. They're not carryovers, so we don't have an emphasis on them, but we kind of need to get that process rolling in terms of creating a bill, having it processed through the revisor's office, and coming back to committee. So in terms of actually having public hearings and work sessions on any potential committee bills, that'll happen later down the road, but we're going to try to weave in some presentations throughout January. This public safety, health, and wellness grant pilot program at the bottom of the page. So that was originally one from the 131st legislature and was amended in 2025. I believe that's largely an HHS or HCIFS report, so I'm not sure if we're going to be submitting any legislation based on that, but we'll cross that bridge when we come to it. And then on the final page, the this top one, you can see this is a Department of Inland and Fisheries and Wildlife. So I highly doubt that we'll have anything to do with that. But we will be receiving the report. So that's it for the overview. I have a couple of other miscellaneous notes for you. First and foremost, there was an email sent out by the executive director of the legislature yesterday, Suzanne Grazer, about an issue regarding some of the emails when legislators have a bill for public hearings and your work sessions, you're notified through that email notification system.
Right.
And there was some issue that those emails never went out. My understanding, it was just discovered yesterday. So they pushed those emails out yesterday. And Suzanne also sent out an email explaining that. But I would double check your legislator email if you haven't already, that if public hearing notices went out or work session notices went out, there's a good chance that you didn't receive them. So if you have any work sessions or legislative meetings today, I think there's 5 committees meeting today, and obviously more throughout the week, there may be a public hearing notice that you weren't aware of. But from my understanding, those emails have been sent out now. So just be sure to check your legislator email to make sure, there might be something this week that you're not aware of. Those notices did go out to the public. So in terms of public testimony, we should still receive public testimony. It's just the sponsors, from my understanding, that didn't receive it. Just didn't receive the notice. Yes.
Yeah.
Yes.
That's good.
So you might have some testimony to quickly write soon. Second, okay, so we already mentioned the Department of Public Safety briefing. Last, Bernice, I want to put you on the spot necessarily, but she sent out some emails about organizing paperwork. Do you want to say anything, Bernice, or would you like me to?
If there's some of your puppies are excellent in summer rainfall, and I need to clean up between days that we meet. I'll put things under there, so you can't do that. So if it needs some organizing, if you don't clean it up, I'm starting a collection of little boxes that I'll put in front of your food that I don't want that. The other thing is I wasn't as good the last year about copying all the reports. I've started a file for each of you. The really long ones, like the fire marshal's report is 34 pages. You've received an electronic copy. If you want me to print one of those longer ones, feel free to ask me, that's fine. But some of the other, all the reports are in the master file. And if your individual folder doesn't have the report you'd like, just let me know. That's that.
Thank you.
And there's cookies over there. Okay. That was the grand finale. So my part's all done. Any questions regarding any of that? If not, we can leave Department of Corrections. Yes, they're here, so we can move on to that. No questions?
Any questions, concerns? Okay.
Okay, I'll hand it over.
Thank you, Will.
Yep.
Thank you very much. Please. Welcome back.
Good morning.
Good morning. Senator Beebe Center, Representative Hassenfuss, members of the Criminal Justice Public Safety Committee. My name is Christine Tebow. I am Associate Commissioner of the Department of Corrections Division of Juvenile Services. Happy to be here this morning.
And good morning. I'm Tony Cantillo, serve as Deputy Commissioner for the Department of Corrections. Good morning. Happy New Year.
Welcome.
So
Yes. Yeah. So thank you for coming in, and I know this is new. This is our first non-LD schedule hearing that we've had. And so just a reminder to the committee, this is an opportunity here to field questions. These are some of the today's schedule is some of the things that in the off session have been I've had conversations with other legislators on, legislators on, or there were things that sort of rose to a level where I felt like it might be good to give this committee an opportunity to question the department about things of relevant nature. And so that's why we're here today. And so hopefully the department can sort of walk us through what happened over the summer with the few incidents that happened at Long Creek, and explain what, some of the circumstances without getting into identifying information or confidential information of that nature, but explain sort of the circumstances, what has happened, and more importantly, what the remedies are. Because in my opinion, any type of oversight is not so much to dwell on what happened in the past, but to look forward and say how we can remedy any missteps in the future.
Okay, thank you, Representative. If you would also like to set the context for a lot of the questions that we're going to probably ask, that would be great.
Yes, just give you a few statutory references regarding some of the provisions that may prohibit us from sharing information or specifically answering questions. I want to point out Title 34A, Section 1216 governs DOC information. And of course, we can't share any information regarding juvenile specific. We can't give names, we can't give offenses, those sorts of things. So we really have to protect the identity of the juveniles at Long Creek. Second is Title 15, 3308A, that's in the juvenile code. And that provision protects juvenile intelligence and investigative record information. And as you might imagine, following these incidents, there was a lot of juvenile intelligence investigative record information. So although we can share generalities with regard to very specific information, we may not be able to provide that absent a court order. And finally, Title 1, Section 402, subsection 3, paragraph Q, protects security plans and procedures from being public records. So anything that really touches upon specific security practices, we won't be able to share as well. But we will do our best to answer questions and be as transparent as possible to all of your questions.
I think what our major concern is how did things happen that the kids were able to escape, and what's being done so there'll be less opportunity or availability to have kids escape. Is that something that
that all seems fair?
That
And
does seem fair.
The
Okay.
thing that we will also be mindful of is our response is not to be speculative of the reasons of why the individuals took the actions they did, just because there may be some pending juvenile charges associated with these events. So focusing on our after actions and what we did discover at the time and afterwards, and the immediate steps, short-term steps that we've taken, and then long-term goals that we have in place.
Okay.
If that's appropriate for the committee for us to share, that's our goal today, to be as transparent within statutory boundaries that Associate Commissioner outlined.
Okay. Are there other concerns, other questions? What we're looking for?
There may be as we go, but I think if they can start.
Okay. All right. Thank you.
You're welcome. So in focusing on the two incidents over this summer from the Long Creek Center, there was an incident in July of 2025 where one individual was able to break out of their room using an item that was in their cell, and was able to break out of that room, and from that event fled the secure perimeter of the facility. And then when that occurred, actions were put in place immediately from the facility leadership and facility staff to also utilize our coordination with local law enforcement to respond, along with our own resources, such as our fugitive investigation apprehension team and other joint memberships that we have across the state to support that. What we were able to accomplish was to apprehend the juvenile within a few miles of the facility in about 2 hours from that incident. So that's the overview from there. And if case is okay, we could stop there, answer questions. I want to leave it up to the committee as not to overwhelm with information, but pace it out so that we can have the conversation.
Thank you. Are there any questions? Yes.
Thank you, Madam
Representative
Chair.
Kennedy.
There's been 6 escapes from Long Creek in the last year, correct?
No.
No.
In the last year, there've been 2.
There was 2 juveniles who escaped almost exactly 1 year ago this July, correct? And then there was another,
There were 2 juveniles who escaped in 2024.
okay,
So that's a year and a half ago.
okay,
1 juvenile who escaped in July of 2025 and 3 who escaped in August of 2025. But
so
the 3
6
who
total in
escaped-
18 months, not a year.
Yes, and the 3 who escaped in 2025, it was one particular incident. It just happened that 3 juveniles were able to leave the facility.
Okay, but 6 kids total have escaped in the last 18 months, or in that 18-month period.
Yes.
Okay, are you going to be able to speak about some of the other I mean, like you just gave us information about this one escape, but there were others. Will you share with us?
Yes.
Okay.
Thank you. Other questions? Representative?
Thank you. And so you mentioned that the July 25th incident, that there was an item used to break out, apprehended within 2 miles in 2 hours. What sense has been done to prevent a similar circumstance from happening again?
Just to correct the date, Representative Hassenfuss, that was July
Ju-
18th.
Yeah, sorry, July of 25.
Yes,
Sorry.
July 18th.
The steps that we took immediately were we reinforced those windows. We identified those windows were rather large, given the setting of the correctional center. That's something that, as a design that was made over 20 years ago, we did not identify that as an area that could have been a possible vulnerability, and that's something we shored up rather quickly to fix those things. Other responses too were strengthening standard operating procedures, as we referenced as SOPs, as far as what to look for during security rounds and other rounds as it pertains to the security inspections across the facility. But that was what some of the major steps we took were taking a look at what egress was made and shoring up those spaces that we could identify to include adding what we call, or the industry calls, anti-climb fencing. So as we know, chain link fences have about 2-inch diameter. People can climb. Anti-climb fences have a smaller diameter in the meshing to prohibit or minimize any sort of climbing, and putting up areas that we identified that was the potential pathway for the individual.
So it really was the fencing that allowed them to get over and out
After he broke
after he got out the window.
yes.
Yeah, okay. Thank you.
You're welcome. We will also share that for those who have been to Long Creek, it's a very large footprint outside. So when they go out, it was also at nighttime. It's very dark. Illumination is limited due to the proximity of residential settings and the jet port. So there's some areas in which previously we tried to push for some modifications. And those are also steps that we've taken within the boundaries through research and with the support of members of this committee to identify what type of illumination that we could put appropriately and utilize. It's a large space out there. And so there was also the concerns of how much resources we put outside the facility look versus inside the facility look. And that's where, we had to really manage our resources at the time, given it was about 8 o'clock at night, and just pulling people in for that response.
Yes, Representative Lookner.
Thanks, Madam Chair. Thank you, Mr. Cantillo. Long Creek was designed originally to hold about 250 kids. Is that right?
You'd have to bear with me. I think it's about 180, 160.
So more. So in today, how many youth are held there?
Currently, right now, census. What is the actual census today?
The actual census today is 45.
45, just
Yes. And I can actually, in anticipation of this question, Representative Lookner, have some very specific details regarding the units. One thing
before you continue, I just wanted to, you were saying that it's a really large facility and it was designed to be large for a much larger population than's currently held there. Would you agree with that?
at that time. But I guess that's what they designed that building for, that type of capacity.
And you think how big the facility is maybe lends itself to kids being able to slip out?
No, that's not what I said. I was pointing out a variable as regards to what the physical current plan of the facility currently exists as.
And one thing we would like to share is subsequent to that incident on July 18th, where the resident broke the window out, there was a similar attempt by another resident. And that was not successful because of the measures that were taken to reinforce the windows, framing on the windows.
Okay. Representative Hassan-Fuss.
You mentioned that, you said we did not identify the windows in the previous built a long time ago. They've since been fixed. When you're looking at potential safety risks or escape risks there, is that in-house staff doing that? Are we contracted with an outside agency to develop that? But how is that plan developed of, what things maybe are we not thinking about that might be a vulnerability for security purposes?
You want to answer that question on our responses to that?
So after the first, what I would consider the first actual escape from Long Creek back in 2024, there was a robust inspection of the facility through DOC, operations all the way up to the director of operations. We had a team of individuals from other facilities go through the building and identified as best as possible other vulnerabilities.
This is 2024.
This was in 2024, right, in the summer of 2024, after that first escape. And so certain measures were taken there. Not all vulnerabilities were identified through that process, but there was a significant response following that. After each of these incidents, there is a debriefing, again, with operations and folks at central office, as well as in the facility and other facilities. I want to point out that Mountain View is very similar in construction to Long Creek. So we rely a lot on experiences from Mountain View and their observations as well. But following those, there's a thorough review of what happened, what procedures need to be shored up, what can we do to prevent these incidents in the future. So yes, we do take these very, very seriously.
Representative Lichtner, did you have a question? No?
Yeah.
Representative Hassan-Fuss.
Yeah, and so in part, in 2024, there was a robust inspection. Was there more done since then after, there's been subsequent escapes after that? And, the reason for my question is what I'm trying to get at is what needs to be done to prevent this from happening in the future? If we're looking back and saying, well, in this instance, they did this, let's fix that. In this instance, they did that, let's fix that. Then we're sort of just plugging holes. But how do you collectively look at everything in a whole in the entire prison system to ensure that we're identifying problems before they happen? We're identifying escapes before it happens.
To answer that question, I think it's a balance. We speak a lot about the main model of corrections and how that fits within static security and dynamic security. Static security being the fencing, the cameras and things like that. The dynamic security being our responsiveness, the people that work there, how we change to adapt to the needs of the individuals at those sites and those we serve. In addition to that, I think we're going to, as well as our commitment to get, an assessment from architectural firms to take a look at what is a need in response to these type of measures that could be pulled from current national standards for construction to these type of settings, and also taking advantage of, like Associate Commissioner said, examples from the past to build upon, those areas that we are known and could maybe anticipate in the future. So it's that blend, but also the commitment to taking on an assessment from a firm to look at gaps that could be modified in the facility, but also balancing to ensure that, we hear the criticism of, Long Creek as a structure, and trying not to make that into a hardened fortress type of setting. It needs to have that balance of static security and dynamic security. You can't have it one way or another. And it's also very fluid on which way that pendulum may swing at any given time.
There are other, yes, Representative.
Thank you, Madam Chair. Thank you, Mr. Cantillo. I was wondering, because you just said, and I know Mountain View is almost identical, like the physical infrastructure of the building is almost identical to Long Creek, but I don't know or can't recall recent escapes from Mountain View. When you have done these like comprehensive reviews of the facilities at Long Creek and you find those like soft spots or whatever, these places that these kids are able to escape from, are you reinforcing at Mountain View as well? Because I imagine they're built the same time frame.
It's a good question. I think what we were referencing were incidents that happened early 2000s.
Okay.
Like, when that facility also housed juveniles. There are areas in which, I'm going to throw an example, if a door lock is going a certain way and we knew that that was an issue at Mountain View, that was the expertise from Mountain View to go, this is how we took care of this issue when we saw it 15 years ago. Are there any similarities? And we went around and said, there are similarities. And how did you respond to that? So those are their steps, not to get too specifics, but that'd be an example for some of those type of areas. And I'm not trying to pass it. I'm just trying to balance, our security.
I forgot the term you just used previously where you talked about the like physical security
Static.
and also the
Static
static
and dynamic, yeah.
security. Are there like different security measures being taken for static security at Mountain View that are not being taken at Long Creek? Or what do you make of the fact that so many kids have been able to escape from Long Creek in the last 2 years and no one has escaped that I know of from Mountain View in that same time period?
So if I may, and we haven't talked yet about the August of 2025 escape yet, and maybe when you hear about that, you'll understand the range of behaviors that we're responding to. So I would characterize the escapes from Long Creek as one of two ways, either intentional or opportunistic. And the two, the one from 2024, July of 2024 and July of 2025 were very intentional efforts on behalf of a resident to escape. Extreme measures were taken to escape from Long Creek by those individuals. And perhaps we can now take this opportunity to talk about the August 2025 incident, and you'll understand how that one is different.
Please.
So, yeah.
That event being more of an opportunistic type of setting where, the individuals went through a door in the gymnasium. And there are areas in which those were inspected daily as part of the procedures put in place that are standard practices that have been put in place. But for that particular day and that particular event, they were able to get through. That egress allowed them to get out in the community, the three of them that were involved in that type of incident. And I think that was, alluding to what an opportunistic event was for those individuals in August. I think to go back to that, and again, I want to balance it because I don't want to present speculation on behalf of the individuals that are involved, given, where they are in their own legal status on that. But there are similarities with Mountain View, the medium facility in Mountain View, but not entirely. It's not 100% match of the physical layout where fence lines may end or start, and other sort of static pieces that were in play. Also being mindful that Mountain View proper has been an adult facility for better part of almost 15 years now. So whatever evolutions they have made since then, no longer housing juveniles, I think that allowed them to make some adjustments there.
Follow up?
Yeah, yes. Thank you, Madam Chair. I guess then so you just said that whatever changes have been made since Mountain View became an adult facility have not necessarily been replicated at Long Creek. Why not?
Back to
Like
our
if they've led
attempt
to more
balance having a facility that doesn't look like and feel like a prison. And this is the constant balance that we have, is trying to maintain safety and security, but also trying to create an atmosphere that is not prison-like. So we may have opportunities. For example, the recreation yards outside of the units at Long Creek have chain link fences. This is within the big secure perimeter. The chain link fences are 6 feet high. Anyone that's met a teenage boy or been in high school knows how easy it is for a teenage boy to jump over a 6-foot-high chain link fence and out into the larger secure perimeter. That would not happen at a facility that is a prison. But we maintained that kind of what you would expect to see in a schoolyard procedure, that structure at Long Creek in an attempt to make it feel less like a prison. That's one example.
And that is a difference between the Mountain View facility and the Long Creek facility, is that design had the taller fences inside where the recreation yards come out from those housing units.
Representative Lookner.
Thank you, Madam Chair, and thanks again for both of you. So just in regards to, you characterize the 3 youth that escaped last July, like that was more of an opportunistic escape, correct?
In August, yes.
In August,
We
okay.
escaped in August.
Excuse me for getting the month wrong. And I'm interested in getting at what is responsible for, or how did it come to pass that we have nearly double the youth in Long Creek today that we had 2 or 3 years ago, where it was hovering around 20 to 25 youth, and now we're up over 40. What's responsible for that increase?
With all due respect, Representative Lookner, I'm not sure that has anything to do with the escapes, and there are many factors. If the committee is willing to hear the response to that, there are many factors, but I would just point out that I don't see that is at all impacts the escape. The increase in population has not affected.
Thank you, Associate
residents.
Commissioner. You don't see how like an increased census, have we doubled the staff at Long Creek in that period of time?
What I'll share about the staff, and I want to maybe reinforce what the Associate Commissioner is saying, if we're focusing on a debrief of these critical incidents, we have increased our staffing levels, and so decreasing our vacancies over the last 3 years at Long Creek. And that's an evolution where it's making promotions that were vacant for a long time, adding to attrition and continuing hiring. So our staffing levels are doing quite well, honestly.
Okay, great. Well, that's good news. But to get to my previous question, why are there so many more youth at Long Creek today than there were back in 2020, 2022?
There's a whole host of reasons, as I think the Associate Commissioner has presented many times in front of this committee, on what the many prongs of juveniles that get involved in the juvenile justice system here in Maine and end up in Long Creek. Is this something that we want to dive into today to answer? It doesn't seem like there's a correlation.
Are a lot of
between
them
the
from out of
population.
state, or any of them from out of state?
Well, I think Representative Hasselfuss, did you want to say something?
Yeah, I was thinking that just a brief answer to that for today's purposes would work. And then knowing that we can delve into that much further in some of the bills that we have coming up, dealing specifically with Long Creek. So this is an issue that we have other mechanisms to address, and specifically thinking the public hearing set for the 12th, I think we can delve into that particular question. And so perhaps a brief primer today, and then come back prepared for that in the public hearing of 1923.
I can answer this, and you'll hear more about this when we present our report to the committee in February.
Okay, that would be good.
Last year, the number of committed residents at Long Creek, committed by the juvenile court, increased from 18 in 2024 to 24 last year. So we've seen an uptick in the number of youth who are committed. 3 of those had very short commitments. Others have had longer commitments. The number of what you commonly know as shock sentences, specific periods of confinement, increased from 14 in 2024 to 24 last year, which is, in my experience, a pretty significant increase. So yes, there is an increase in the number of youth at Long Creek. We haven't dived into the length of stay, the average length of stay. As you know, there are 2 juveniles who've been there for months and months due to some very significant charges that are pending. There are, I believe, 3 or maybe 4 youth there who are pending bind over. in the Superior Court or in the juvenile court to go over to the Superior Court. So there are factors beyond DOC's control that influence who is at Long Creek. So you'll hear more about this when we do our presentation, perhaps in the context of next week's bill, but also when we do our presentation to the committee in February.
Thank you. Senator Siroy, would you like to introduce yourself and ask a question?
Scott Searway, I represent District 16.
Mike.
Senator Scott Searway, I represent District 16, which covers Albion, Fairfield, Waterville, Winslow, and Oakland. And I just, I had contacted Commissioner Liberty about this, probably 2-3 months ago, right? And asked him, you know, what seemed to be the issue and that we should hear this. And I appreciate you coming up and doing that. I want to thank you for that. The one thing that he did mention that they replaced some plexiglass and I didn't hear about that yet. I don't know what happened there. Why would the plexiglass be an issue? What happened?
So that the strength of the plexiglass, along with the width of the actual window, we may have spoken that before you came in the room, Senator.
Okay.
So what we did was replace those glasses to materials that were needed updating, like, you know, it's a facility that's quite old and may have been weathered. We also reinforced those windows with metal plate bars so that it minimizes the gaps as well. So that was the immediate response to those areas. Question.
So did they get broke or?
They got broken.
They did.
Yes.
Okay. All right. Thank you.
Representative Milliken.
Thank you, Madam Chair. Thank you, Deputy Commissioner Cantillo and Ms. Thibodeau. Deputy Commissioner, Associate Commissioner. There's so many different titles. You mentioned that, so you talked about the 6-foot fencing around Long Creek. The last time I was in Long Creek, I asked some of the kids how often they go outside, and they had told me at that point that they hadn't been out in several weeks. And so I'm wondering if you could talk about how much time the kids at Long Creek have access to recreate outdoors, and if that's consistent or you know what I mean? It feels like if they're not able to go outside, I don't know why the 6-foot fence would matter, except that these kids escape from the gym door, it sounds like. But could you talk about their ability to go outside?
If I could ask just to follow up on, provide context on when you went to visit Long Creek and when you got that response.
It was several months ago. It was probably 6 months ago at least.
Maybe after close proximity to one of these incidents?
I don't think so. It wasn't that recent. I mean, the most recent escape was in August, and it was prior to August.
Right, it was in July, perhaps?
It may have been sometime in the
summer. I only shared that because one immediate thing was to stop and pause and take a look at what's going on, what are our procedures, any gaps, things like, do we have the right staffing ratio to bring out, you know, the nighttime record? And I say nighttime in the summertime, 6, 7, 8 o'clock, there's still daylight. Is that an appropriate time still, given the matrix of the staffing and other resources and other things that we were being planned? So there was an immediate pause of outdoor recreation in particular events and settings that we paused as we went through this. Again, we didn't want to have an incident and just say, well, we got him back, so we can just go back to normal. That what felt like pretty irresponsible. So a pause on some of those activities did occur as we assessed what were the needs to minimize future events, not put other youth at risk, staff at risk, the community at risk at that time. Recreation, outdoor recreation occurs, obviously limited by cold weather that we're in right now, but we host field day events, you know, throughout the warmer months. We host events inside the gymnasium too when the inclement weather. So there are robust activities going on, and we're also still bringing youth out into the community that are eligible for community passes, recreational events, and other opportunities too. So there was a pause, but it allowed us to balance because we can't just say we're done, you know, and put the static security and that's it. How do we balance it with the dynamic security and identifying what other static security measures we need to improve upon, replace, or add to the facility?
So
follow up?
Yeah. Are the kids at Long Creek able to recreate outside regularly?
Yes.
Okay. So I've asked a couple of times. Every time I've gone in, I've asked, and it doesn't seem like they have. I haven't heard, I guess, from the kids that they're able to go outside that often.
And that's feedback I'm glad to hear. Associate Commissioner is glad to hear, and we have the superintendent behind us too, to make sure that that is followed up on. But from my observations, that does occur. And admittedly, there was a pause after each of these events as part of the response to it.
And if I may add to that, having the opportunity to go out and choosing to go out are two different things. So if you ask the residents, have you been outside lately? They may say, no, I haven't been out for weeks. And that may not be a result of any prohibition on them going out. It may be because they choose not to go out. So I would just caution that when you ask residents the questions, that what you really want to know is, are you prohibited from going out, to ask that question carefully.
Representative Perkins, would you like to introduce yourself?
Thank you, Madam Chairman. Representative Chad Perkins, I represent District 31.
Representative Lookner, did you have a question?
Yes, thanks, Madam Chair. Just got a couple of things I want to ask before I gotta get going to my other committee. I'm just interested to hear more about the conditions that preceded some of the youth who were more premeditated in their escape attempts. Were any of them, I've got a couple questions here. So not just conditions, but like, were any of them specifically held in segregation for longer than 22 hours in a 24-hour period of their cell, and maybe like a couple-week period prior to them escaping? And couple years ago, we were hearing a lot about specific incidences in which there were a group of youth acting out in a manner of, breaking equipment in the facilities, and that outside law enforcement had to be brought in, and a number of these youth were held in prone restraint with like a knee on the back for several minutes at a time. So I'm just wondering if any of the youth involved had been held in any conditions resembling that, if there'd been incidences in which, kids were restrained in some manner, either held in isolation or restrained by staff or outside law enforcement.
No, not to my knowledge.
Follow-up question? Okay. Representative Hassenfuss?
So I'm just curious, and once again, I'm going back to those assessments, architectural firms, whatnot, but are there any single points of failure that have been identified? So for instance, I'm thinking of escaping through a gym door, right? If that's the only barrier to, to fully escaping, are there other situations like that where there's just one single failure point, and if that is breached, then security is breached? And have you been able to identify situations like that through, your outside contracting?
Yes, and some of those have been immediately remedied. So in closing that area that we identified was a vulnerability was one that we did in short time. And as we went through that exercise, took actions to also reinforce areas that had maybe some similarities or could lead to similarities with those type of events.
Yeah. And so were there, single, failure points identified in any of that?
I wouldn't necessarily say single. It was kind of a built, you get through one area and then another opportunity was present that also opened up to us that also needed to be addressed and followed up on too.
So, for example, on the August 15th incident, the doors were checked manually by staff that morning. The doors were not attempted to be kicked open. So the normal practices in securing the facility were followed. And when it was discovered that the door was not as secure as a routine check would lead us to believe, we took steps, obviously, immediately to fix the door and to create a secure perimeter outside of the gym.
And so for that particular instance, was it just as simple as kick open the door and then?
With a lot of force.
But
with much force.
Okay, and so what I hear is there's no other, that to the best of your knowledge, there's no other areas where one single, no matter how much force you're using, one single
Correct.
push through the door, climb over the fence, jump out a window, that alone is not going to be enough to fully escape the security infrastructure.
To this date, yes, that's how we feel right now.
Representative Lookner?
Yes, sorry, I just, can you confirm that none of the youth were held in segregation for like a 2-week period prior to them attempting to escape?
We would have to probably go back to, I don't have that knowledge at the top of my head today. I was not prepared to answer that type of question. So we can go back and get you that response.
Representative Hassenfest, you have another question?
Well, just on Representative Lugar there, perhaps if for the February report, if you can just, identify instances where individuals have been held in segregation or other types of things for Representative Lookner. You've heard these questions, perhaps if you can just help facilitate that at a later date, I think that'd be appropriate.
Representative Lookner?
Yeah, if I could just add one more thing to that, if you could, not just segregation, but perhaps other incidences in which youth were held in restraint by staff or just general conditions that may have lent themselves to the youth not feeling as though they wanted to stay put.
Would you be willing to do that with
We
that?
will look at that data, but I also want to be mindful of any speculative, explanation for the youth taking the actions that they did. But the objective questions, we can provide the objective response to it.
And with regard to the August incident of last year, frankly, I think the residents were surprised that the door opened. So I would not characterize that as the residents trying to get out. I think they were surprised themselves. And again, it was opportunistic. They left. Many didn't. I want to point that out as well. Many residents did not leave through the open doors. 3 did, many stayed. So I would not just to get to your point, I don't think in that incident there was any like, oh gee, we got to get out of here. We're being,
Representative Lavoy?
Thank you, Madam Chair. I'm not sure how to put this, but everything that you've talked about today is based on experience that you've had through the process. In other words, you've learned from the individuals that actually accomplish those tasks. However, have you ever had anyone of the same age group? And even then, I'm at a backdrop, and I'll tell you why. In that facility, that would be looking for potential areas of escape. And the reason I say that to you is because my mind today at 80, no, yeah, I'll go 80 years old. It's quite a bit different than an active teenager that is thinking one thought, that is not being in that establishment and trying to find a way to get out. He will be studying the individuals that work there. He'll be studying the structure and everything that he can, or she. There's a reason for it, and the reason is because that individual does not want to be there. Thinking a lot differently than the individuals that are overseeing the facility. So it's just a thought. I don't know if that's ever come up or anything like that, but just listening to the situation, I will say to you that you may try to do everything you can possible. And tomorrow morning, you may find someone on the outside. So I just thought I'd put those comments in.
Well, thank you for your comments, Representative. And if I am just summarizing what you're sharing is how we put ourselves sort of in a perspective of a youth that's out Long Creek and how we would perceive our time there and in the vision's perspective. Is that somewhat accurate of your comment?
Yes, it is. And even doing something like that, that particular individual would not have the same mission as an individual that has been put in there for an altercation of sorts. Do you understand what I'm saying? In other words, if that would happen, this particular individual is free at any time he or she wants. Whoops, I'm terribly sorry. There we go. But they have a different frame of thought, is what I'm saying. Between individual A that is in there for some type of altercation and does not want to be there, in opposite of an individual that you may put in there of the same age group with a mission to try to find different ways to accomplish an escape task. He may not have the same thought process, although he's in the right direction, but he doesn't have the same thought process as this one or as much need to be on the other side as this individual. So there, you still have a difference there. You know what I'm saying? So it is a difficult task. And I feel for you, I really do. Because that's a daily situation.
I'll respond to that. That's why the importance of static security needs to be there. And the level of how static something can only be as long as expectations and other things are in place. That has to improve and modify. But more importantly, or as importantly, is our dynamic security, the people that work there, the relationships, the culture, those things. That can't be stagnant either. That has to be fluid and be responsive. So that's engaging with the youth. That's why there are those standards of, how frequently there are checks, interactions, schedules, all those type of things at the baseline, the floor of a standard and not the ceiling of a standard for us to meet and improve upon.
Would you like to begin to summarize?
The August 25 incident?
Yep.
Any questions before we may move on?
Representative Milliken?
Thank you, Madam Chair. Could I just ask for each of the three incidents, right? There was the July or the 2024, then July of 25, August 25. Can you talk about the time frame between when the escape happened and when the facility knew that there had been an escape? Or and also for the gym incident specifically, what staff were there staff in the gym who were witness to okay.
So I'll quickly on that. July 24, very quickly, notification. The July 2025 one, they knew that he went through the window. And as I mentioned, it was unsure at the time, was he still in the larger recreation yard, still inside the single perimeter fence? Or did he in fact, get outside of the secure fence? So there were a set of resources identified for that particular one. Was he left or was he right? Essentially, utilizing resources such as infrared cameras from our law enforcement support. When we had law enforcement there, they went around the perimeter to shine lights into there to allow for illumination. And then we discovered based upon the teams that were staged that he was no longer inside the perimeter. So that was a little delayed, but actions weren't taken to either or. It was for both situations for that event. And if that satisfies it, I'll go to the gym incident for August 25. Staff were in the gym at the time and immediately pursued the residents out. Obviously, we can't flood everyone out there immediately because we sought to control the situation at hand, but immediate response to include a foot patrol from our staff going out there, immediate notification to law enforcement, and also securing the facility with the staff present inside the facility to maintain order. And then for us to establish incident command and an executive command post to establish our response for the incident.
And then how long between when the kids walked out of the gym or ran out of the gym and when they were back in the facility?
It was about 10 or 11 hours. They were actually apprehended through incredible efforts, a team of people. What happens when there is an escape is we have a central control at Long Creek where we have communication with our law enforcement partners. So it includes our FIAT team, Fugitive Interdiction and Apprehension team, South Portland Police Department, obviously, and DOC resources, both juvenile resources and adult community corrections, other facilities. There were a number of people. That one, because the residents, when they left the gym, were in the non-secure, they were outside of the secure perimeter, they ran very quickly, and it took a while through intelligence operations to determine where they were, and they were apprehended in Saco by Saco police. And a collaborative effort to apprehend them. And they were apprehended at different times. They were, once they got to Saco, they split up. And so they were all apprehended, but right around 11, somewhere between 10 and 11 and a half hours with them all to be back.
One thing I will add to that particular day, there was another major critical incident involving Maine State Police, local police, I believe it was in Oxford County, that was happening simultaneously. So as we had our own canine units and resources to help support that in South Portland, there was efforts to divert resources to respond to another critical incident in the community. So not saying that may have been a delay, but obviously it was an impact. It was in the time of the year too. We have to have the right conditions for the right resources to go out there. We're prepared to utilize South Portland Fire Department if we needed to patrol the shoreline of Long Creek, the actual Long Creek, into the Fore River, just as any sort of those assets could be put out there. But that was a duration. It was a longer duration, given some of those variables I just mentioned.
Representative Ardell.
Thank you, Madam Chair. Do you think it fair to say that these escapes are a consequence of an agency tasked with maintaining a secure facility that doesn't have the look or feel of a secure facility?
I think that what we identified as a buildup of these events, taking lessons learned, because I will also be frank that there were critical incidents that occurred at Long Creek within 2024 that, thankfully the residents did not escape the actual perimeter. They did break windows, they did do damage to housing units, and that, took that journey of us reinforcing and taking those responses and lesson learned from other incidents, how we may reinforce or react and respond differently to those type of things. I think it's the balance of what footprint, what floor plan, what the expectations are for us to support and manage youth in our care and custody, balancing with how do we evolve with the times and other expectations that this committee, the state of Maine, wants us, to take care of those kids. But I think that'd be a loaded question for me not to appropriately answer today on that. I think it's us learning truly, like, what do we have in play? What resources do we have? And not just being satisfied with status quo, and how do we improve upon those types of things? We also want to be protective of not blaming the individuals that are there. That could be easy enough for other people in my chair to say, did we take a look at X, Y, and Z? We started taking a look at ourselves first and what steps we needed to take to improve upon those areas.
I think you hit on the key word, and that's balance, where, maybe there could be a little more weight put on security as opposed to, and I don't even know what you would call it, the appearance of not being a secure facility. But that was a great response, and I appreciate it. I think that addressing that concept of balance is a very wise approach.
Thank you.
Yes, Senator Searway.
Thank you, Madam Chair. Something I hadn't heard is security levels. I know that, you've cut back to a small number that's there now, and they are probably more medium and maximum security individuals than they were before. And when you had 300, you probably had, when you had 300, you had some minimums and whatever. But so did you beef up the security areas for those levels? I guess that's the question I have.
I think that goes back to the balance of dynamic security and static security. The custody levels, or other levels you may allude to, are different than they are in the adult system. And we recognize that. We know we can't manage it the same way. We also know that there needs to be constant presence of incentives, opportunities, and structure to support the day-to-day for the youth in our care. That's where that dynamic security, where, I mean, we can't just say, let's lock up the doors and throw away the key and let's just keep everyone there like that. We cannot evolve that way. So as we develop what opportunities are there, we also have to be mindful and have multidisciplinary team reviews who are those individuals, who are those youth that are eligible to go on community passes and community events outside the facility, who need to continue to maintain progress, within their own structure. We also have a balance of individuals that are committed youth and also those who are, pending trial as well. So that's that balance of how we respond to all the situations at Long Creek. But I think where we are taking the measures to respond to areas that were vulnerability in the past or could potentially be vulnerabilities, are where we're putting those resources to reinforce the windows. Again, the static pieces, putting in fencing that was not there before, or identifying areas that need to improve upon of those structures.
Just follow up on that.
Okay, follow up, Senator.
So, I was an assistant jail administrator, and I know that, and I understand what you're saying about, how the change is happening and all this, but at the same token, you have responsibility in keeping the public safe. And so what I don't understand is how it would change as far as the security part for those secure levels. Because you can always work it down to minimum security for somebody that you're trying to get out or whatever, but you still need to have that safety factor. And so how's that perceived any different than even a jail? I mean, you have to have that. Some of these are serious, and I don't know what the percentage of the 5 individuals were, but I'm sure they were probably either maximum or medium security. It probably sounds like.
Senator, do you have a question?
Yeah, and the question is, how do you maintain that secure level?
If I may take a stab at that. So most of the youth that are there, we have some history with. We know if they've been at prior residential placements and they've eloped, or perhaps they've been, missing from home. They have a risk of fleeing, risk of flight, or that they may have particularly aggressive behaviors and a motivation, to use your scenario, a motivation to want to leave Long Creek. We have to assess every individual on a constant basis. And because they are young, because they are growing, those risks change, right? So a youth who is very high risk when they come in may over time settle in, get the proper medication, get the proper structure, and no longer present a risk. So yes, I think it's fair to say that we don't have a tool that we actually measure who are the high-risk kids today, but I know that the staff are in constant communication about how their youth are behaving. And also looking at their history is a big factor in determining who are the ones that we should keep a closer eye on and use more of that dynamic security to focus on those youth. So to your point, yes, there are high-risk individuals. I think we do a fairly good job of identifying them and providing that dynamic security.
I guess the question is that the error piece, or is it the security area piece? Because when you get somebody maximum, you got to treat them as a maximum security. And that's what I'm saying.
I think that, when the youth come to Long Creek, if we profile them just for the reason they got there, I think that would be an unfair start to their time at Long Creek to begin with. everyone that comes in has the full access of assessments and other resources that are there to identify what does Long Creek stay mean for them, and not them as whatever is on a sheet that came with them from the law enforcement officer. So it's really beginning that journey from day one on what those individuals are. And some have different restrictions at the beginning, some have different access at the beginning, whether it's more or less, depending on it. But given their time there, we're going to use all the resources there to identify what is the steps for progress for each individual. And that's going to look different for sure. And that it does require responsiveness based upon risk, other factors, institutional behavior, the ongoing patterns of things. But ultimately, we want to have the individuals become the best versions of themselves while they're with us and in charge of our care. So I think it goes back to balance. It is not me trying to be coy, a question down the road, Senator. It is a balance, especially for youth in our care.
I want to thank you very much for your presentation and for your willingness to answer all of our questions. If you would like to finish, that would be great.
So we left on the August 25 incident.
Yep.
To answer Representative Milliken's question, there was immediate response because staff were in the gymnasium along with advantageously, it was in the middle of the day, so it was a lot more staff in the facility, not that responded to the foot pursuit, and then consequently the establishment of the command posts for us to establish our response long-term as needed. So they were apprehended rather quickly through intelligence and other factors that we had within our assets, internally the DOC and our partnerships with other law enforcement agencies to apprehend them within the community in time.
Excellent. Are there any other questions? Representative Hassenfuss?
Yeah, first, I'd like to thank the department for coming in today to sort of, clear the air on all of this, give the committee members an opportunity to ask questions. Just my final request, I'm just curious if you can take some parts of that, assessment that you received. I don't want to know anything that's, sensitive or could be a security risk, but if you could just sort of summarize, here were some, issues that were identified through the assessment. Here's some of the recommendations and, things that we're doing to improve this. Now, obviously have that be the stuff that anybody walking through the building could see. You don't need to detail the more sensitive information, but if you could just kind of give us a summary of what's been identified, issues, we didn't think about, the firm has identified for us, and then how we're going to remedy that situation. I think that would be helpful. Yeah.
We can do that.
Okay.
Are you asking for that right now?
No.
Just at some point in the future, if you could just, and it doesn't have to be long, it can just be a short, summarized version, but I'm just curious to see like what the bullet points are on things that have been identified and what we're doing to address those.
We can do that, and I will like to thank the committee for us to be able to share this and for having the understanding where, statutory limitations are in our balance and response, and make sure we're as transparent as we can as a department.
Thank you very much. Thank you. Yeah, so we're gonna have anything from public safety?
Yeah, we have the whole,
We do have this thing. Yeah. Can we take maybe a 10-15 minute break? And then we'll move into public safety?
Be back at 11:10.
11:10?
We'll start promptly at 11:10.
11:10 we'll start?
It's right down the road.
Yeah. What I like is I got these rollers and I just put it right on the roller and I can roll it anywhere I want. He's ready. I can.
Yep, we're coming.
My wife got a snowboard.
We were just talking about that.
My wife got a snowboard tractor. I never used it.
Okay, we're going to resume our meeting. And I've asked Representative Hassenfass if he would give us an idea of the scope of public safeties.
Excuse me, I have to.
Oh, go ahead,
We'll
go
let
ahead,
everybody- we'll
go
let
ahead.
everybody sit down.
Yep, everyone can sit down. Welcome. Okay. So Representative Hassenfass is going to give us an idea of the scope of this presentation because it changed a little bit from what we put out.
I'm just
Welcome.
I'm just gonna let everybody get settled in here
Yep.
and. Okay, good morning still. We're back here with the second part of our morning agenda for the Criminal Justice and Public Safety Committee. And I'd like to welcome the Department of Public Safety up here, headed by Commissioner Sawchuk. As noted from our letter to the department, we were going to discuss the proposed transition of the Capitol Police to transition to state police. However, we're going to delay that discussion as I anticipate that there will be a bill coming forth where we can have a committee review of that proposal. So we won't be taking any questions or having any briefings on that particular piece today. So what leaves us is the second agenda item on the letter, which would be a briefing and a review of the police use of force policy for the state police and from the Maine Criminal Justice Academy and policing at large. And once again, as I mentioned before in our previous hearing, this is an opportunity both for the department to explain the processes and give us a briefing on, certain policies, procedures, what's happening, as well as to allow the committee members to ask relevant questions to try to satisfy any curiosities we have, with the idea that, any oversight hearing, the aim is not necessarily to litigate specific cases or, point fingers about what happened in the past. But the aim is to ensure that moving forward, we have proper procedures, policies, regulations, and laws in place to ensure that the agency is adhering to the appropriate standards that we all would like to see in this committee and the public at large. And so with that, we'll turn it over to Commissioner Sawchuk to run us through the wonderfully crafted report that he has provided for us here. And then we'll open it up to questions from committee members. Commissioner, would you prefer to just take some time and run us through a briefing and then we can ask questions, or do you prefer that questions sort of come organically as you're going through this?
So first and foremost, good morning, and Senator Beebe Center and Representative Hassenfass, distinguished members of the Criminal Justice and Public Safety Committee. Thanks for having us. It's good to see everybody. Welcome back. We know you're hitting the ground running, and you got a full agenda, and it'll be packed over the next few months. So before I get into the topic at hand, I just want to say again, thanks for having us. But more importantly, if you need anything at all throughout the session, please reach out. Any questions, language, opinions, hey, what about that thing? Just call somebody, and we're happy to either drop in or jump on the phone or jump in the hallway and kick it around. So we're happy to do that.
Thank you, Commissioner.
Yeah, we're honored to be here and honored to help out. I would also say Representative McIntyre is not here, but I did want to say in a public forum that the good representative helped us out with a Secret Service training with behavioral threat assessment in the off season. that I know that Representative Nutting was attended, about 90 people total, some staffers, some legislators, good mix. And it was great, with the representative and his experience was able to call Secret Service partners that he worked with for decades and able to put that together. And I think it went very, very well. And that's a great attendance for off session when you're all home working on constituents issues and trying to mow the lawn, try to catch up on stuff.
Yep.
But it was great that he put that together. And I wanted to say that out loud. And he knows that I've told him myself, so maybe I'll mention it again when he's actually here.
Okay.
But I did want to say that. So I know you're busy, so I will dive in. So as Representative Hassenfuss had mentioned, that second item there in the memo, I'm going to hit like that 50,000 foot view of what this really looks like. As you know, and as you've heard me say 100 times during budget hearings, the Department of Public Safety has 10 different bureaus. So there's 720 or so employees. The law enforcement aspect of those 10 bureaus would include the Fire Marshal's Office, Maine Drug Enforcement, Capitol Police, and the Maine State Police. So when we're talking about disciplinary processes, complaint process investigations, those are those four entities which would really be in play. The vast majority of today's conversation, I'm going to ask Lieutenant Colonel Brian Scott, who's the number 2, the deputy chief in the Maine State Police, and is an incredible asset for me and all the DPS and for this committee. One of the primary roles in his position as the number 2 is around discipline, is around complaint process, it's around budgets, around policy. So Brian's perfect to have this conversation today. So in the vein of we're here for you, if you have questions, throw something at us, whatever it is, and we're happy to stop. We will kick it off with a little bit of a presentation, but we're happy to stop wherever. And in a conversation with Representative Hassenfuss before we kicked off, really we're initially thinking 90 minutes. So if that means 45 minutes to an hour for one issue, we're happy to be here for 30 minutes or 2 hours, depending on what you want to do. So when I hit that 50,000 foot view, what I mean by that is the Maine State Police, to me, they utilize a best practice model with professional standards, which is why Brian's here to kind of walk through that. The other law enforcement agencies that fall under that DPS family umbrella would naturally kind of fall under a human resources investigation model. And that means that there's a complaint that comes in, it comes from internal, external, whatever that is. There's a referral to HR. They do an investigation from their standpoint. So we submit an allegation potentially or forward an email from some member of the public. And then they are going to take that investigation. They're going to run the whole thing. And they're going to come back to us at the end with some kind of a recommendation. And then we'll be involved at that point to determine final discipline. In consultation with the AG's office, and all those partners are at the table for these kind of things. We talk about statutory authority. That comes from 100 different places, to be honest with you. It comes from policy, it comes from union contract, comes from rule, comes from statutory language. So depending on exactly what the situation is, will depend on what lever you may be pulling to investigate something or ultimately utilize discipline as appropriate. I don't think that's a stretch for any other industry out there anywhere in the world. It's kind of a standard process. Brian, again, can touch on notification. It's very regimented on the state police side of the house, probably for obvious reasons, but there's notifications and letters and allegations and what that means, and then how we kind of roll through an investigation. And that information is included with policies that you have in front of you, forward-facing public policies that are in here. And I appreciate our reality here is, again, to talk about policies and process. It's not to talk about specific cases, which we won't do. You're not going to ask us those anyway. I know that. Right. But that's just a given on our end. And another aspect of a potential complaint process would be at the end of that, at the end of some of these scenarios, or at the beginning of others. If there's a criminal allegation, as an example, a chief law enforcement officer would have a 30-day mandate to report that activity to the Board of Trustees at the Maine Criminal Justice Academy. They have a subcommittee, which is incredibly, incredibly busy, called the Complaint Review Committee. It's a 5-member committee. 2 members of that committee are mandated to be civilian members. And that particular committee would then have a hearing process. Again, very regimented with a hearing officer and a representative representing us from the Attorney General's office. There are informal conferences, there are hearings, there are subpoenas, there's a whole thing that goes into reviewing each and every one of those cases. Ultimately, that committee would come forward with a recommendation that then goes to the full Board of Trustees, which I'm a member of the Board of Trustees, ex officio based on this position. I have been since I got in here for 7 years. So every other month, we have a board meeting, and once or twice a month, every month, they have a complaint review committee meeting because their volume of work is such that they are very, very busy. So it is not uncommon at all for the Board of Trustees, again, every other month, to decertify somebody, to utilize aspects of the disciplinary process, the disciplinary statute, and those guidelines to address an issue. And just like any other scenario, of course, we run into scenarios where it's unfounded. We don't believe that anything occurred. But they do that investigation anyway. They do that follow-up anyway. I brought the statutory language here, not as part of your packet, just to go through what some of those disciplinary options are. So again, so you hear some of these. Denial of an application for a certificate. That means that an applicant rather, comes in and says, I want to be a police officer in fill in the blank agency. And as part of their background process, they say, well, but when I was a kid, I was drinking underage at a pit party and we burned a barn door down as part of a fire, right? Just what does that mean? So that goes through the process and says, well, is that a disqualifying conduct? Is that an arson versus criminal mischief versus anything at all? What does it really look like? And that complaint review committee looks at it and they go, that we're going to deny that individual's application for a certificate because they don't apply. They committed offense. And the criminal offense is anywhere from a class A to a class D. Your felonies are A, B, and C's. A D is a misdemeanor. They do not review class E's, which is the lower end of the pool for misdemeanors. Issuance of a warning or censure or reprimand, suspension of a certificate for up to 3 years. So somebody already has a certificate, right? So they're already an officer. They're already a corrections officer. They're already, we do handle other things at the academy other than just law enforcement. And then whatever occurs, the board ultimately decides to suspend somebody's certificate for 3 years. Revocation of certificate, that means that's a career-ending decision. That means we're pulling your certification. You can no longer be a law enforcement officer in the state of Maine. And that's a regular occurrence in the Board of Trustees meetings. I think that's at least once, if not more than that, every meeting that we have. There's a situation where that takes place. Imposition of civil penalties up to $1,500. Conditions of probation. And then on the low end of that is a letter of guidance, which was used to educate, reinforce knowledge regarding legal or professional obligations, or express concern over action or inaction by the certificate holder that does not rise to the level of misconduct sufficient to merit disciplinary action. So a letter of guidance is not discipline, doesn't rise to that level, but it's just saying this is a concern that we have, and we're letting you know, this is in writing on the books, that we feel that there was an issue here and you need to be aware of that for education one way or the other. There's also something that was just brought into play, and I don't have the exact date in mind for the legislature, and that was standards of conduct. Was an expansion above and beyond the criminal activity that may or may not occur that would be alleged against the certificate holder. Now there's standard of conduct conversation. And I will tell you that as a member of the board, I will tell you as a chief of 7 years and now a commissioner for 7 years, that there are also scenarios just like any other walk of life where you're like, I don't like what happened here. I don't know that I can prove that it was criminal, but I do think there's an honesty issue. There's an ethics issue. There's something that doesn't quite fit the traditional model for discipline or review. So cops, you don't lie, you don't cheat, you don't steal, right? It's not, there's a whole code of ethics stuff. We can recite it and that's powerful, but it's pretty basic, right? I mean, you wear a badge, you carry a gun, you have the authority, the responsibility to take somebody's civil liberties away as far as putting them in jail if they've done something, using deadly force if something has happened. So those people need us, me, as a 30-year cop in one level or another, married to a cop. We all need to be held accountable for those things. And the standard of conduct piece was something that we just couldn't get at as a board. There are different ways. You talk about honesty, you talk about truthfulness. There's Giglio standards. There's all kinds of things that could have a negative impact on a criminal case, as an example, and have a negative impact on an individual's career if some of those things occurred, and they should. But as a board, we had difficulty getting at some of those kind of issues, which is where this expansion, and actually came through this committee, to have that expansion into standards of conduct. Now, we've had a few of those cases to this point. I don't have an exact number for you. A few of those cases going to that complaint review committee to take a look at. I will say that some of those things are a little bit more loose than a criminal standard that says this happened and therefore there's a violation of that and you can't be a police officer. To try to prove truthfulness, as an example, or some of those things are a little looser and harder to get at. But it's important that we try to get at the truth and try to figure that out. So we appreciate, as a board, and I'm a one voting member of an 18-member board, so certainly don't speak on their behalf. But as the Commissioner of Public Safety, I appreciate the opportunity to try to take a look at those cases and adjudicate those cases to the best of our ability in a hearing process. So that's some of the academy piece. There is a minimum standard in here, a model policy on use of force from the academy that we'll get to as we kind of move through this. But that's kind of my end of that 50,000 foot view about what this thing looks like. These processes are cumbersome and for all the right reasons, that there's due notice and all those things that we need to comply from an investigative standpoint, by policy, by rule, by contract, by law. So everybody deserves the proper representation, proper notice, and everything else across the board, which is what we try to provide on a day-to-day basis. I will also say this, that there are literally hundreds of boards across state government. And I appreciate all of them. I'm a member of a number of them. The Board of Trustees at the Maine Criminal Justice Academy is an incredible group of people that work very, very hard. And their board meetings, our board meetings, are routinely 6 or 7 hours long. The Complaint Review Committee, they're all volunteers. And that the Complaint Review Committee has a bunch of homework, and then they have a hearing, and then so they're meeting up to twice a month on top of a 5, 6, 7 hour Board of Trustees meeting. So they are good people. It is a working board, then some. So I want to make sure that I say that out loud. They're working very, very hard on our behalf. They take it seriously. There are just and honest conversations and debates and tough decisions. And they're from my perspective, for whatever it's worth, they're making the right call. And if somebody needs to be decertified, then they're doing that. And we're not happy about it. Nobody wants to, in any walk of life, you don't want to see anybody get jammed up, but you need to do it when it's appropriate. And the board is doing that as appropriate on a regular basis. So that's my spiel, 50,000 with a couple different things. The DPS family kind of jumped over to the Criminal Justice Academy a little bit on the back end. Happy to take any questions on that. I'm not sure I said anything of note, but then I will be happy to turn it over to Lieutenant Colonel Scott to kind of dig in a little further.
Yeah. Senator Searway, do you have a question?
Yeah, thank you, Madam Chair. I just, listened to what you had to say, and a lot of times I think a lot of people have, and tell me if I'm wrong, if there's a misconception, sometimes they don't hear what actually happens, because it's usually kept kind of confidential when they decertify somebody or whatever. And so is that seem to be your understanding? There's a lot of times that you hear complaints or whatever and on somebody, and it's usually because they don't know the true facts or whatever took place.
Yeah, so I mean, you've been through the system and worked in it for many years. I think the reality is that from a law enforcement perspective, there's not two sides of the story. There's usually 20, right? You're trying to figure out what you saw from your angle, what happened over here, what does that all look like? And I'm a foot away from Brian, and my view could be completely different from somebody else. And so it runs the gamut from you will see final agency action, as an example, is public information. You will see that the proceedings of that criminal review committee our complaint review committee are confidential, right? So in that scenario, we shut off the mic. We're having a conversation in depth about what happened on what day and what does that exactly look like. We have that conversation, we come back on the mic, and then everybody votes in public about what they think. So the back end of that is what everybody hears. They don't hear the blood, sweat, and tears behind when the mic goes off about what that looks like. And nor should they, right? It's a confidential process. That's all fine. Having been involved as a final discipliner, right, on the top of that chain for a long time and in the largest municipal agency in the state of Maine. And now I'm involved with discipline for my bureau directors, right, at that level. They take care of their particular agencies. You know, these are decisions that are incredibly important to develop culture and to make sure that we deserve the trust and relationships that are so important to make us successful out in the community, right? We have to do that. We have to uphold that standard. So that's incredibly important and should be, certainly is to me. I know it is to the Maine State Police and everybody that works with me every day.
Thank you.
Are there any other yes?
Thank you, Madam Chair. Thank you both for
Yeah,
being
good to see
here.
you.
I have a question around revocation. Will we be going into that with more detail? No.
Sure. So we talk about revocation or decertification. Was that what you mean?
Yeah.
So on that end, sure. So that's something that ultimately the Maine Criminal Justice Academy doesn't certify law enforcement agencies, as an example. They certify individual officers. Same way as on the Department of Corrections side, we certify corrections officers, not agencies. So yes, that we would be in a position to review those kind of cases. The complaint review committee would make a recommendation. The board would have a final vote.
And you mentioned that in your board meetings, you get quite a bit of this.
Yep.
How many are we talking about per year? And does this follow the officers in the state of Maine, or does it how does this work exactly?
So I don't have an exact number for you. We do have an annual report that the Maine Criminal Justice Academy and the board puts out every year that completely dials that right down to all the different levels of discipline that I mentioned and exact numbers of what that looks like. My apology. I should have brought that for the entire state. I was thinking we were going to discuss the DPS end of things, but I can tell you that at this point in time, it's not uncommon for us to see, 15, 20 cases when the Board of Trustees meets. And keep in mind that means there's a bunch of stuff queued up, right? So they're working through this hearing process and the complaint review committee. It may take them, a few months from beginning to end to make all those arrangements, get all the information that they need in advance so that they can come to a recommendation and then forward it to us. So I don't have an exact number, but we see those, constantly. It's a conversation. I will tell you that this committee as well expanded the number of people in the review committee because we only had 3 and they were smoked. I mean, you're looking at a full case and then you're reporting out on that case. We had to expand it out to at least 5, and that's probably not enough in order to keep up with what we have.
Follow up?
Yeah, thank you for that. So when an officer or somebody gets.
Oh, you
revoked-
asked that. I didn't answer it.
Yeah,
Yeah.
Does that just pertain to the department they're with, or does that apply to sort of anywhere they go?
Right. So they're decertified, and you asked that question and I failed to answer it. So the decertification, you're no longer certified as a Maine law enforcement officer, period. So you could go to another state and apply as part of your background. Then you're going to have to explain exactly what that looks like. And those agencies, those states are going to have their own standards. As an example, we require polygraphs in the state of Maine, Massachusetts and New York do not. So there may be a different process, a different scenario, but being decertified as a law enforcement officer across the state is a big deal. So any agency that tries to hire an individual that's been decertified, they will know they have to follow up with the academy. That follows them throughout the rest of their life. I would say the rest of their career. They don't have a career. They're not certified, so they're out. So that will definitely follow them. Some of these other things, you can have a letter of guidance that's going to be with the academy in that file. And as part of a hiring, you're going to reach out to the academy and say, is so-and-so on the list in any way? And then they have that conversation about it. Anything that's public, anything that we can reveal, that we would do that. Yep.
Representative Milliken?
Thank you, Madam Chair. Thank you, Commissioner Sawchuk. I have a several questions, but I'll try to just for right now, keep it to a couple. What information is made besides the decertification? What disciplinary information for officers is made available to the public, and how does the public access that information?
So the final agency action is what's public information. So the investigation itself, that final agency action would be whatever it is, termination, suspension. There's different terminology, and I'll let the Lieutenant Colonel kind of touch on that terminology. Different contracts have different levels of discipline. What's disciplinary versus, as an example, letter of guidance? It's not disciplinary in nature, but that would be in somebody's file as well.
Okay. And then you talked about the board having this oversight and when you have complaints, how do those complaints come in typically?
So depending on the type of complaint, right? If we're talking about a complaint review committee criminal case, then that chief law enforcement officer is the individual. I've done it myself in this position they have a form, you fill out the form, you submit it to the complaint review committee through the academy, and then they will take it from there. So the reason that we had requested a paralegal and we received that in the last budget process is because this is a very it's a lot, right? So that paralegal's intended now, and we still haven't hired it yet. So the director of the academy, the assistant director are the ones that are gathering information from all these different parties and setting up hearings and providing subpoena information as appropriate and doing all that work on the front end. So that's how that style of complaint enters the system. If somebody has a complaint reference to standards of conduct, they can also submit information directly to the director of the academy or the assistant director and run with it from there.
And then you mentioned before, and I think I just didn't quite hear you, the Attorney General has a seat on this board, or is what, I know that certain incidents are investigated by the Attorney General's office, like use of deadly force. So what, is that the only incident that would only be investigated by the Attorney General's office, or how is the Attorney General involved in these investigations?
So the Attorney General's office is our attorney, is the Board of Trustees attorney. So they're sitting at the table providing legal advice and also participating in the complaint review process as an attorney for them. So that's the aspect of that. The AG's office is not an active voting member.
Gotcha.
And I think there's a conflict of interest there piece, right? So they're providing legal guidance. And then the board has their opportunity to vote however they see fit. But they are providing guidance as our attorney.
Yes, Representative Hassenfuss.
So going back to the confidentiality piece, and in my understanding, and correct me kind of where I'm wrong, but it's similar to like a physicians, the Board of Physicians and other professional organizations that have, the review process, not for criminal conduct and not even for civil conduct, but just for, are you falling within the standard of practice that is expected for somebody within that profession? And it seems like that is what's going on here through these complaints. But I think in those instances, they're more public, they're not confidential. So what in that process is confidential? And then at what point does it become public and what becomes public? I'm just trying to tease out, whether this information should be confidential or whether it should follow sort of similar other professional boards and be open to the public essentially. And so that the individual could say, well, there were 3 complaints filed. Those were all dismissed, but I can at least see what happened. I can go through this process. So if you could just walk through the confidentiality piece for the committee, I think that would be helpful.
Yeah, so I think there's a component of this. I don't know enough about those other processes to compare them, so I apologize for that. I would say that there's a piece of this that it's a personnel matter to a certain extent in their certification. I could circle back with you exactly what, as not being a member of the complaint review committee, so not sitting through those hearings, I don't know exactly what that looks like. What I would say is that if we have a conversation, generally speaking, when we hit the complaints, it's about an hour and a half, maybe 2 hours that we're going through 20 cases, right? So we'll shut the mic off. We're going to go into executive session because we're going to be discussing confidential matters. It's all part of the law. Read that into the record, into the microphone, shut the microphone off. And then each individual member of the complaint review committee is the lead on a specific case. So I'm the lead on this case. I'm going to read off what happened, what the complaint review committee thought, back and forth. We asked these questions. We didn't ask these. We didn't think we got a good answer on that. The individual had an attorney. We did all that stuff. And then the complaint review committee comes forward with a recommendation. We go, okay, that's good. The board chair is literally taking notes on every one of those on a case. And that it's a pink piece of paper, right? Because it's confidential and it just has a whole list of names on it. So he's taking notes on the first case. We move on to the second one. The next member of the complaint review committee gives their synopsis of what happened from their notes, give a recommendation. We all listen. We have an opportunity to ask questions. And then when we come back into open session, into public session, the microphone goes back on, we'll come back on the record. And then somebody will make a motion to say, we want to do this with this particular case. There's a second of that. Sound familiar? And then there's an opportunity to have comments or to ask additional questions. So that happens in a public forum. And then after that, at the end, we're all going to vote on those particular cases. So that entire roster, as if they're finalized, the final discipline will be something that's open to the public.
And in your opinion, do you think that initial conversation needs to be or should be confidential?
I think the Attorney General's office would say that it needs to be confidential. I mean, we're following a standard process. We're not wading in. That's the process that was in place when I got there. Not a huge fan of that's the way we've always done it. But when you're talking about legal process and we're following their guidance, and that's the process that we have to work with. So it is confidential. We hear that on a regular basis. We don't have those conversations, off the mic. So yeah.
Any other, yes, Representative Milliken.
Thank you, Madam Chair. Thank you, Commissioner. When you are doing these investigations, are you inviting every person who is witness to the incident in question to come and speak before the board to talk about what they witnessed?
So the complaint review committee in a hearing setting would invite witnesses, victims, complainants, whatever is appropriate from the investigative side to come in and have that conversation. Yes.
Are there any other questions for the commissioner? Representative Hassenfuss?
And that's all confidential.
Yes.
That piece of it.
Correct.
Thank you very much.
Yeah, thank you. I got a big mouth. That's a lot longer than I had thought, so I apologize.
Well, there were a lot of questions.
So much for 50,000-foot view. I apologize.
Welcome.
Good morning, Senator Beebe Center and Representative Hassenfuss, members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Brian Scott. I'm a Lieutenant Colonel with the State Police. And when I get into the Office of Professional Standards, that is one of my duties oversee. I'll talk a little bit about the qualifications of myself and the rest of the members in the Office of Professional Standard. But before we get started, if it's okay with the chairs, what I'd like to do is present the packet that was passed out to you. That's one with the blue binder on it. The second stapled package that I sent out is just the annual report that's now required to be presented to this committee. I think the first one was for January of 2024 that we had to submit on rural patrol and policing. So I passed that out as well, just so you would have it. Didn't plan on going over that today, but if you happen to have questions on it, happy to get to that. So I'd like to talk about the complaint process and how that actually starts. It's really simple for the state police, but I want to remind the committee, I can only speak on behalf of the Maine State Police. We don't supervise the other 150 or so police agencies in Maine, so this process is particular to complaints on Maine State troopers. So if there are complaints, any member of the public can reach out to a trooper themselves and make a complaint on the spot and say, I want your supervisor's information. And our policy requires that they provide our supervisor's name and contact information. They can make a complaint in person. They can walk into a barracks anywhere throughout the state. They can call by telephone to a dispatch center. They can call to any one of the barracks that's manned and make a complaint. Which does happen, but I think probably the majority of the complaints come in through online reporting. It's so easy nowadays and so convenient, and most folks seem to have the devices in their hand. It's easy to reach out to the Maine State Police. So on the Maine State Police main page, on our landing page, as soon as you Google us up and hit Maine State Police, our landing page has two places right on the front cover that indicate it's a box that says, I want to, and it lists some options. One of them is, I want to make a complaint. That is right in the center of the page. And then on the bottom of the page, we list our Office of Professional Standards and our captain's name and contact information. Both of those have hyperlinks that send a person who is on our site directly to a complaint page with information on how they make a complaint, to include an online reporting tool that they can use to download a form and fill out. And we can receive that directly in the Office of Professional Standards. If a supervisor or a dispatcher receives a complaint on a trooper, then they have to follow our policies, and our policies are that it gets ran up the chain of command to the Office of Professional Standards. And I want to talk about that just a little bit, and if it's okay with you, the first tab after your letter is the Office of Professional Standards. That statement that we provided for you, we wanted to make you aware that the staff at the Office of Professional Standards have diverse law enforcement experience. They've been employed by the Maine State Police for between 22 to 28 years, and combined, they've held a variety of positions throughout the agency. We feel the foundational knowledge is critical for the handling of personnel investigations, ensuring that they're done fairly, thoroughly, and objectively. These investigations are conducted to maintain department integrity while respecting officers' rights and while building the public trust. In the Office of Professional Standards, we've got myself that oversees it and 4 full-time members that are in that unit. So myself, this is my 28th year in the Maine State Police, followed by 4 years with the Kennebec County Sheriff's Department, where I started my career with your very own Senator Scott Seaway over there. I think he was probably in the middle of his when I was in the beginning of mine. My time with the state police, I've had an opportunity to not only do the patrol work, which is where all troopers start out, but then to move over to our support services side of the house and our traffic division for about a decade. After there, I left and went to headquarters as a major overseeing our operations division, which is all of our field troops, the commercial vehicle enforcement unit, and the Maine Turnpike Troop. Then I transferred over to the support service division as a major, where I saw the other half of the department, which are things like all of our specialty teams, things like the computer crime lab and traffic division and fleet and supply and those types of things. In 2022, I moved into the role that I'm currently in as the lieutenant colonel. And one of the responsibilities, again, is to oversee the Office of Professional Standards, amongst other things. The captain in the unit that oversees the unit and the staff there directly on a daily basis, he's on his 28th year with the state police and spent 19 of those years, almost 20, in the major crimes unit. He left the major crimes unit as a commanding officer, so as the lieutenant. He's investigated dozens and dozens of homicides, child abuse cases, sexual assault cases, and other heinous crimes. The sergeant that he oversees that is involved with the investigations portion of the Office of Professional Standards is also on his 28th year. We're classmates. He has 17 years that he spent in the major crimes unit and the computer crimes unit. You folks have heard of our computer crimes unit past, and I can tell you they are certainly investigating the most heinous types of all crimes that occur in the state of Maine against our most vulnerable population, which is our children. And you can remember, when they're working those cases, they're working those cases to present criminal court to prove cases beyond a reasonable doubt. They've got the skills, the training, the knowledge to pull off what we're asking them to do to investigate personnel complaints. We also have another sergeant that's in the Office of Professional Standards. It's a recent addition. It's something that the department thought was really important, and it focuses on proactive audits. And it's also to move our agency towards the MLEAP accreditation process. I'm sure the committee's familiar with MLEAP. You've probably heard about it several times, but happy to answer questions later if you have any. So that particular member of our department has got 22 years on and has spent the last 10 of those as a sergeant. But throughout her career, she's had an opportunity to also work in very analytical roles and investigative roles, covering fatal motor vehicle crashes and those types of things, resulting in prosecution. And supporting the 3 of those folks, we have an office associate too that takes care of administrative and clerical work for us. And the next tab that I wanted to go over is our policy that discusses OPS. It's pretty lengthy, so I didn't want to go through the policy itself, instead summarize what it is, but I included it. That's policy M7. I included that so that you would all have it as a resource document if you wanted to refer to it at some point. So my goal is to summarize at a relatively high level.
Thank you.
And then if there's any questions, to be more specific, because I don't want to bore you with the details, but I think it's important to understand what that process is. So the complaints that we receive, whether they're the online or through a supervisor or somebody walks into the barracks, when they make it to the Office of Professional Standards, that initial complaint is screened. It's screened by our staff, whether it's the captain or the sergeant that's in the unit, to determine what type of complaint is it and what the next steps need to be. The next steps depend upon a lot of things. The commissioner had mentioned earlier that we have to consider things like collective bargaining agreements or the contracts that we have with our employees, civil service law, other areas of state law, federal law. In addition to federal law, we also have to consider our human resources, Office of Employee Relations, the Attorney General's office, and all of the guidance and rules, some that are promulgated pursuant to statute that govern the state employees or civil service processes in Maine. So it can get pretty complicated pretty quickly. But we have to make a determination as to what type of a violation are we looking at? Is this a complaint where maybe a trooper was driving over the speed limit without lights, or is it something much more serious? And that initial conversation determines the path. Pursuant to our collective bargaining agreement, since 2017, we've made some changes. We're able, as an agency, to go in and take a look at things like videos, body worn camera, cruiser camera, read investigative reports, read use of force reports, and all those things without ever putting a member under investigation. That's a legal term in the collective bargaining agreement, where if we're putting a member under investigation, we've made a determination that there's probable cause to believe that there is a violation of our policy, misconduct, or potentially a violation of law. If we believe it's serious misconduct and a potential violation of the law, that's when we have kind of a bifurcated process where we would make contact with the Attorney General's office and report to them any information that we had regarding the case. We seek guidance and counsel from them. Sometimes they will, at that point, take a case and they'll say, we're going to investigate that. If they investigate it, we hold our personnel investigations pending the outcome of the Attorney General's office, generally speaking, because their case could result in a criminal process at the end, and we want to make sure that we don't jeopardize that. We also have a responsibility, if we think it's serious misconduct that could result in a decertification or a revocation of a license or a suspension. As the commissioner had mentioned, we have an obligation to report that to the Maine Criminal Justice Academy as well. If that investigation is staying within the state police, we make a determination if it's going to be investigated by the Office of Professional Standards personnel themselves, or if it's going to be investigated at a troop level, either by a troop commander or a unit commander that might go in and review a case in its entirety and then report back to us if they feel that there are any issues. If a case is sent out from the Office of Professional Standards, this is all prior to putting a member under investigation. If it is sent out into the field for a troop commander or a unit commander to review, the instructions are pretty simple. Take a look at this, and then while you're looking at it, if you review something that you think is a violation of policy or misconduct, you stop, report that back to the Office of Professional Standards, and we'll take it from there. Once that probable cause level is established, if it is, then the Office of Professional Standards will put a member under investigation. It's a process that is outlined in our collective bargaining agreement where we have to provide proper notice to a member. We have to tell them that they're under investigation. We have to give them 48 hours and say, hey, we want you to come in and we're going to interview you as a condition of employment. So you have right to union representation. What we're ensuring throughout this whole process is due process. That's something that's required under federal law, and I'll touch a little bit upon that when I get to some of the outcomes here. So once the complaint is investigated, either again through the Office of Professional Standards or through a field troop, that entire case is presented from the Office of Professional Standards to me, to myself in my office. We talk about the case, they tell me about the facts of the case, and then I make determinations as to what the outcome of the case is. Those are included in this M7 policy. The possible outcomes or finding at the end is that I sustain a case, and that says that, yeah, you're guilty of what you were accused of. If it was unprofessional conduct and we sustain it, then we take a look at, okay, what's the appropriate remedy? Is it counseling? Is it discipline? And I'll talk about what discipline is in just a moment here. The finding could be not sustained. Not sustained means the case did not provide enough evidence or information for us to make a determination one way or the other, did the alleged conduct actually occur? That's a very, very rare category. We usually, because of the strength of our investigative team, they usually don't leave a stone that's not unturned. So we usually are able to make findings in cases. Not sustained is a very rare category, but it is in a collective bargaining agreement, so I wanted to mention it. We could determine that a case is unfounded at the end, saying that it has no basis. In fact, it didn't happen at all. We could exonerate, which could be, yes, there are facts that this occurred. However, it's appropriate based on the circumstances. It's appropriate based on training. It's appropriate based on the totality of the circumstances to include our policy in some of the other guidance that I had mentioned earlier. Or we can close something out as informational. Informational is a category that's usually used for things like if we have completed an investigation and we've decided it doesn't rise to the level of misconduct, but it's a performance issue. There's room for improvement, right? Police officers, Maine State Troopers, they're certainly not perfect. We're air to make mistakes. And when we do, it might not rise to the level of discipline, but it doesn't mean we're not going to do anything at all with that case. We send it back to the troop and we tell them to counsel, to train, to do the appropriate thing, to remedy it, to make sure that the conduct doesn't continue if we've determined that it's not appropriate, but doesn't rise to the level of discipline. So those are the 5 categories that we can close out a case. And then part of this will end up falling in with what's discipline and what's a public record or not that Representative Milliken had asked about. So after a sustained finding, I'll just talk about that one particular category, then we decide, is it appropriate for the member to be disciplined? And we consider things like prior history and progressive discipline. So for us, discipline is a corrective memo or above. That might not be the same. Matter of fact, it's not the same for all agencies, but it is for ours pursuant to a collective bargaining agreement or our contract with the Maine State Troopers Association. So what that basically says is at the end of the finding, if it is final agency action, I just wanted to touch on this before I forget, that part becomes a public discipline record unless it's under appeal. So during the period of time that it's under appeal, it is not public because it's not finally agency action until the end of the appeal in front of an arbiter. So there's a process that they're allowed to follow. But the progressive discipline that leads up to sometimes more serious discipline, it depends on history and the severity of the case. So for us, a corrective memo, that is something that stays in a personnel folder or in our Office of Professional Standards folder as well for 1 year. That's the lowest level of discipline. If it is a written reprimand, then a written reprimand stays on file for 3 years that can be used if the member continues with similar conduct in the future towards that progressive discipline. A suspension, that stays on their record for 5 years. A demotion, forever. Termination, that's information is retained for at least 10 years after departure from employment with the Maine State Police. And that's pursuant to a rule that was promulgated by the Secretary of State's office. They have rulemaking authority for discipline records, and that was a standard that was in place. As far as the progressive discipline, the severity of an incident could result in termination, and it does at times. Or it might result in the first step is that corrective memo, a written reprimand right up through. But the severity of it could also result in a suspension or a demotion for a first offense. But when it comes to other things that require a progressive discipline, those timelines are all spelled out in a collective bargaining agreement. I didn't provide a contract. They're pretty lengthy. I'm happy to, if the committee decides that's something that you want, I can send you a link that's got the contract that I'm referencing. The second contract that we take a look at is the Maine State Law Enforcement Supervisors, or better known as FOP, the Fraternal Order of Police, and that covers our lieutenants and above. Resignations and retirement during an investigation. I want to talk a little bit about that because historically for us and for many law enforcement agencies, if a member retired or resigned in the middle of an investigation, the investigation it stopped. There was no finality to it. It stayed in a queue. They started an investigation. The member's gone. You can't discipline them. You can't interview them any longer. So prior administrations within the state police, those cases kind of remained in limbo. In 2022, after having an opportunity to hear from many of you that are sitting in this room and the Judiciary Committee and the Right to Know Advisory Committee and other folks on transparency issues, as we learned more and more about that, we felt it was inappropriate to allow a member of the Maine State Police to retire or resign in the middle of an OPS or Office of Professional Standards investigation and not conclude it. Because if there are findings of misconduct at the end of it, it might be revocation worthy from the Maine Criminal Justice Academy Board of Trustees standards. And if we don't complete that investigation, they could retire, resign, and then go apply to another police department and work for another police department. So again, since 2022, the state police has taken the position and adopted a policy. It is part of the M7 that you'll read, where we shall find we have a finding. We will conclude an investigation at the end. It is much more challenging.
Yes, Representative Nutting. I know.
Thank you, Madam Chair. I'll give the Lieutenant Colonel a break for a second. Let him think about it. The Attorney General, who is the state's attorney, and the attorney for the Public Safety Department, is the Attorney General, if the answer is yes, is he involved in any of this process that you've been going over in detail? If he is involved at any point, can you tell me how?
Thanks for the question, Representative Nutting. No, they are not involved. They take the investigation and then we follow theirs, or if we run parallel, we make sure that we don't interfere with theirs, but they don't work on our personnel investigations. The only oversight that really comes is our Office of Employee Relations, which is part of our Bureau of Human Resources, has guidance from the Maine Attorney General's office on civil service law and those types of things that guide our processes, but they are not involved with the processes that I'm explaining right now.
If it were found that a state trooper violated some law in the performance of his or her duties, would the Attorney General then be the person to bring the legal complaint? He ceases to be the attorney for the department and becomes the attorney for the state again. Is that a fair?
Yes, if I understand you correctly. So
I wouldn't be surprised if you didn't.
What does end up happening is if it rises to the level of criminality, the Attorney General's office might choose to go by way of a grand jury indictment, or they might criminally charge our member. And so their investigation would take precedence over ours. We would take any information that they derive from theirs to include what could potentially be a conviction. We haven't had this happen in my tenure, but we could take a conviction. Then we would continue our personnel investigation and use a conviction for a crime as part of our basis for discipline, which would be termination.
Thank you.
Sure, you're welcome.
Yes, Representative Milliken.
Thank you, Madam Chair. Just a follow up. You said that's never happened in your tenure, the Attorney General. No trooper has been charged with a crime in your time working for the state police.
In my tenure as a lieutenant colonel. So since 2022, I'm not intimately familiar with every case that's ever occurred in the Maine State Police, but since 2022, they have.
Okay. And are you enjoying your break? Can we ask more questions, or should we continue to allow you to keep talking?
Totally up to the committee's pleasure. I've got a few more things and I might end up getting to some of the questions, but I'm happy to answer them as we go as well, ma'am.
Okay, can I just ask a couple of things that just kind of came up while you were speaking? One is when you have disciplinary, if you take a disciplinary action against a trooper and that information would be public, where would the public go to find that information?
It's a great question. So generally, that's subject to FOA. So, and we do on a regular basis receive requests, and those requests are usually for things like discipline records for the Maine State Police since 2015 or since 2010, and then we provide those records at that point.
So the only way for the public to know if you have a state trooper who is engaged in, I don't want to say engaged in some they're engaged in some kind of misconduct. The only way for the public to know that would be to submit a FOIA request.
Unless they were a complainant in a case. If they're the complainant, we provide them with the outcome.
Okay. Is there, and this, you might be getting to this, or I don't know if this is something that you plan on talking about, but is there like an average number of like use of deadly force incidents that an officer might have over the course of a career? Do you follow that question, I guess, or does that make sense?
I think I understand what you're asking, and I would not have that information. It's something for our agency that I could get that information and report back to the committee. There are many members in the Maine State Police who have never been involved in an officer-involved shooting or deadly force, and others that have been involved in several, especially if they're on a specialty team like a tactical team, and they're exposed to greater risk over a longer period of time than your average Maine State trooper would be. But I don't have those numbers right in front of me.
And then when you are looking at use of deadly force incident, do you look at a history of use of deadly force for this trooper as well?
So we're talking about complaints in general. I haven't talked about use of force, but what I will say is that we do not investigate deadly force. That's what the Attorney General's office does.
That specifically.
So we investigate non-deadly use of force.
Okay.
And you may be familiar that, so the AG's office is doing that, what I would describe as a criminal investigation against the officer in question. Is a homicide justified or not, right? So then on top of that is a deadly force review panel, which again, as an ex officio member, I'm a member of that. And that group meets every month to look at deadly force scenarios. And the AG is to determine whether that's justified or not. And it's up to us as a panel to look at training and policies and equipment and all of those kind of things, which is not his purview. We don't look at the justification and he doesn't look at the policies and equipment and things of that nature.
And what you find, Representative Milliken, when we do get to the use of force policy, we do have an internal review team, but we specifically carve out, they're not responsible for the deadly force determination of being justified or not justified, because that is up to the Attorney General's office. But we do review for things like policy, equipment, training, and if we could have had better outcomes. And those are what we call IRTs, those incident report team reports, those are public at the end as well.
And you'll see I apologize, you'll see an annual report from the Deadly Force Review within the month. That I think that's our 6th total report. So it'll be coming back to this committee as well as judiciary shortly.
Representative Hassenfuss, do you have a question?
Yes, thank you. So we've talked about the complaint review committee from the Maine Criminal Justice Academy, and then we have the Office of Professional Standards within state police. At what point does the state police say, okay, this is something that rises to the level that we should refer it to the MCJA?
So it depends on when we learn information in an investigation. If during the course of an investigation, we learn something that leads us to believe that there is some type of a violation that was committed that could result in revocation or suspension of a license, then we're required to report it to the Maine Criminal Justice Academy at that point. If the allegation is a crime, and as we start our investigation, if there's probable cause to believe that that may in fact be the case, then we would refer that at that point to the Attorney General's office.
So there's a couple of off-ramps. One is you're reviewing a case, okay, potential crime, Attorney General's office. Okay, that now something, it doesn't rise to the level of a crime, but it rises to the level where the individual's professional license might be in question, then MCJA. And then if it doesn't rise to either of those levels, then we just follow through to the professional standards of the state police to go through one of those 5 adjudications that you've previously mentioned. Is that a fair assessment?
Yes, sir. Well said. That's accurate.
Representative Milliken.
Thank you, Madam Chair. Maybe a little outside of your purview, but who does this type of investigative work when a sheriff's officer is involved or a municipal cops?
So I would say that as a local control state, they're going to have their own process. The vast majority still call it internal affairs, professional standards. And as the Lieutenant Colonel had stated, to have investigations and an inspection aspect of professional standards, policy development, things of that nature makes a lot of sense. But an individual agency, an agency down south that I'm familiar with would have a full-time lieutenant and sergeant doing internal affairs investigations. The vast majority of agencies across the state are very small in nature. So we may have, 40 major crimes unit detectives. Another agency has a patrol officer and a chief. So everybody's wearing 12 hats. You don't just take a report and pass it off to somebody. You're doing the whole thing, right? So if there's an internal affairs investigation, maybe they have the skill set and the resources necessary to do that internal. They may refer that to somebody else to ask for assistance. You see a lot, maybe they hire a law firm, maybe. So it just depends on what they're looking at and what they're dealing with to make that determination. It's not uncommon. It doesn't happen that often, but I say it's not uncommon to have an agency have one of their officers involved in a real-time event. And then they respond and they go, I'm not going to investigate this. This is Cletus, his locker's right next to mine. I've known him for 20 years. So I'm going to call and ask somebody else to come in and do that criminal investigation on the front end. So it does vary. It's a great question, but it does vary all over the board. Yeah.
Okay, thank you. Would you like to continue?
Absolutely. Thank you. What I was talking about, I think when we left off, was if there's a sustained finding, there are different things that we do by way of discipline. If it is formal discipline, which for us is a corrective memo up through termination, then we have to do proposed discipline. That's part of the constitutional law that comes out of Loudermill. If you're familiar with it, it's a 1985 case out of Cleveland, Ohio. And it basically says that a civil service employee, a governmental employee, has the right to due process if you're going to deprive them of property. But there's actually 2 district courts that are outside of the First Circuit that have said you have a liberty interest in your position with a governmental entity. So liberty could be things like if it impacts your reputation. So it's really easy to separate if it's Loudermill, because Loudermill is property. So if they're being suspended or demoted, they're entitled to Loudermill because that impacts their property. You take money away from them. But if it could damage their reputation, although this isn't the United States Supreme Court case, again, 2 circuits have said you have an interest in your liberty, which could be something that damages your reputation. So we do Loudermill hearings for any discipline, where we give the member an opportunity with union representation, if they choose to have it, to come in, have a formal on-the-record meeting and be able to challenge our decisions. Basically, what they can come in and say is, your investigation is flawed, and I think you reached the wrong conclusion, and here's why. Or they could come in and say, I agree with your finding. What I was, accused of doing, I did, and they fall on their sword and say I'm responsible for it. But I think your decision on punishment is too harsh, or I might say the penalty doesn't fit the crime, it's too severe. After that process takes place, then we do final agency action. That final agency action becomes public unless it's appealed. And then we have to wait for the appeal process to go through to determine what an independent arbiter would say about that case. If an arbiter decides that there was no wrongdoing, then the record remains, but the officer's name gets struck. If there is a finding that the officer, or they agree with the state police and they say that the finding is correct, it's sustained, and your punishment is appropriate, then the entire record, including their name, becomes publicly available. So there's just a little nuance with that process. And then if you looking at the back, before you flip to the bias policy, if you look at the back of M7, the second to last page is just a citizen complaint form. That's an online form that can be downloaded. It can be filled out online. If they download it, they can write on it. They can send it in. They can write on it. They can hand deliver it to a barracks. I just wanted you to see what a complaint form looks like. And then so we're still in the tab that says the Office of Professional Standards. The very last document that I provided there is the Maine State Police Office of Professional Standards, and it's a summary of sustained complaints for the last 6 years. It's not overly detailed. We put this information together pretty quickly. We usually have till the end of January or so to try to come up with annual reports and those things. But I wanted you to have the information in front of you so that you can see that the Office of Professional Standards complaint process has resulted in, this is aggregate numbers for you. In the last 6 years, 4 terminations, 3 demotions, 15 suspensions, 163 total suspension days, 10 written reprimands, 6 corrective memos, and 2 resignations. Those resignations, I had talked about that a little bit earlier because we went with final agency action at the end of those with sustained findings. So we can't impose discipline, which is what the statute requires, but the statute also says you can uphold. So when a member retires, we can't suspend them, they're already gone, but we can uphold our decision to suspend them. That's how it becomes a public record. One of those, I just wanted to put in that note category. One was a written reprimand case, relatively low level, and one was a termination case, but we did follow through with those in this final agency action. As far as the excessive use of force reports, annually, we at the Maine State Police, like every other law enforcement agency, the chief of the department is required to submit a report to the Maine Criminal Justice Academy on the total number of excessive use of force complaints that the agency received during that year. I provided those numbers for you as well, so you could see those. 5 is the largest amount in any one year in the last 6-year period. During that same period of time, I wanted to point out that our total use of force report submitted. Now, you have to understand, when I say report submitted, that's the trooper doing their job and doing a use of force report that's required pursuant to our policy and I'm going to go over the next one, which is our use of force policy. But they've got to document any amount of force that's used other than compliant handcuffing. So if they say you're under arrest and somebody turns around and puts their hand behind their back and they put the handcuffs on them, no report. If they say you're under arrest and the person pulls away and you grab their elbow and pull them towards you so that you can restrain them, a use of force report gets done. So we do them anytime there's any force used at all outside of compliant handcuffing. And you can see during that period of time, the numbers actually climb. There's an explanation for that. Happy to get into it if you have questions. Otherwise, I'll move past to some of the more aggregate data. When I looked at those 1,217 use of force reports that were submitted, out of all of those, there was only 21 complaints of excessive use of force. So that's 1.73% of the time when a trooper does a report on the use of force, do we receive a complaint that it was excessive from the person. Looking at that next line down, it's just our total arrest, because I wanted to put that into perspective. The Maine State Police is the largest police agency in Maine, and we effect a lot of arrests. The total arrests during that 6-year period was 23,434, resulting in 21 excessive use of force complaints, which means 0.09% of the time when we make an arrest do we receive a complaint that we used excessive force. The next category that I wanted to include is our bias-based policy. And the reason for the bias-based portion of it is.
Could we ask a quick question?
Yes, ma'am.
Representative Bunker?
Thank you, Madam Chair. Use of force reporting, something specific to your agency internally, or would we find similar reporting requirements as municipal or county department? That's something more exclusive to yours?
Your microphone, Representative Bunker.
Yeah, Representative Bunker, this is the Maine State Police policy only. I can't speak to what other agencies do or don't do in regards to the complaints that they receive or in regards to use of force reporting. This is an internal document that we use.
Thank you.
Thank you.
The next policy that I wanted to include is the Maine State Police General Order M5. It's the Maine State Police policy. It's regarding the investigation of bias-motivated incidents and prohibiting bias-based policing. Now, the majority of that policy, that is if a Maine State trooper receives a complaint from someone in the communities that we serve, and they say that I have been targeted as a result of a protected class. So whether that's race, gender, sexual orientation, anything that's included in the Maine Civil Rights Act. If somebody feels that their rights were violated and that they were the victim of that, we have a policy that dictates how that complaint goes. But how this ties in is on the last page of that. I think it's page 5 or 6. Okay, so page 5, there's a portion of that specifically directs the Maine State Police that says that bias-based policing is strictly prohibited and we won't do it. And if there is an allegation, it says those complaints of bias-based policing and any other such discriminatory practices by Maine State Police personnel must be promptly referred to the Office of Professional Standards. So there's this general category of complaints. Then if it's bias-based based on the Maine Civil Rights Act, then we have to follow this policy in addition to. The next tab is on our use of force. And the very first document is a flow chart. If this flow chart were to be followed, this is dealing with the reporting requirement that I started to talk about earlier, where if a trooper arrests someone and they resist and any amount of force is used to effect that arrest, we have a flow chart that is derived directly from the policy that follows that in the book, which is the M use of force policy. It's 22 pages long. So I wasn't planning on going through that because it's very detailed, but that flow chart can take you through how complaints are received and how they can be received at any point throughout. one of the requirements on the use of force report is as soon as a trooper fills out that report. So they're doing a report for their use of force, but they're also doing an incident report that's related to the event that precipitated in the force being used, which is generally going to be a criminal incident that we may be charging an individual with. But they are required to do a use of force that's separate. That has a review process with checks and balances, and that's kind of what the flow chart here demonstrates. The checks and balances are, it leaves the trooper and goes to the immediate supervisor. The immediate supervisor has to review that report and investigate, but it's really a review. Investigate might have a legal connotation or certainly one that's in the contract. So they're doing a review at their level. Do they believe that it's appropriate? If they have any concerns whatsoever, they're to immediately file a complaint with OPS on that particular case. If the supervisor, the immediate supervisor approves that, then it gets forwarded to the troop or the unit commander. That's a commissioned officer with the state police that holds the rank of lieutenant. The lieutenant will review it, and if the lieutenant has any concerns, the lieutenant is to report it immediately to the Office of Professional Standards. If the lieutenant in the field troops or in the units don't have any concerns, then the next stop along the way is it gets sent to the training unit. The commanding officer at the training unit is a lieutenant who also will review the use of force and involve the subject matter experts that we have that are our defense tactics or mechanics of arrest, restraint, and control, MARC instructors, to review these cases to see if there's anything that we can glean from a training benefit or from a policy benefit. If everything makes it up through the training unit and there are no issues, it's sent to the Office of Professional Standards as a repository. It's archived in that location. There's not a further level of review if there's not a complaint. It's just the repository at the end of the day. Our processes have changed. Fortunately, this used to all be, you fill out this form and email it. We now have a computerized database called Blue Team that a trooper does the entry right in the computer that can automatically go to the sergeant, automatically go to the lieutenant, and then we have this repository now that still sits in our Office of Professional Standards. That M1 policy, I want to talk about it a little bit because the complaint process is very similar if we receive a complaint on excessive use of force. And in the letter that we received from this committee in particular that said complaints, but how do you deal with excessive use of force complaints? So we follow M1. And when we're following our own policy on that, we're also considering state law and we're considering training and we're considering federal law. The standard that we have to take a look at is Graham versus Connor. That's one of the most recent United States Supreme Court cases that governs law enforcement use of force. It's a 1989 case. That really tells us what we can and can't do, and our policy is modeled after that. When the United States Supreme Court decided Graham in 1989, what the court said is that they understand that law enforcement is operating in a tense, uncertain, rapidly evolving situation, and they don't have the benefit of deliberation. And it's unfair to take a look at that use of force with 20/20 hindsight, that you have to take a look at it from an officer who's on scene, and it's an objective reasonableness standard. That's what comes from Graham versus Connor. But what it says is you have to evaluate at least 3 circumstances that have commonly been referred to as the Graham factors. So we're taking a look at the severity of the crime, because that's required. You take a look at the degree or the risk of injury to the public or the officer, and the amount of force that is being used to resist arrest or to flee apprehension. So it's also considered the totality of circumstances. And Supreme Courts just made that ruling last year because there was some division amongst circuit courts, whether it was a totality of circumstance test or whether it was a moment of threat test. We now know, based on the most recent decision that came in 2025, that it is a totality of circumstance. It means you have to evaluate the case in its entirety, not just the very narrow specific moment that the threat arrived that the officer used force or not. So we follow the Graham standards when it comes to that. At the end of that M1 policy, what I put in there was a tab forward. It's an electronic report. It didn't come out very nicely, but it's a tab forward report that's done in the Blue Team for the trooper that uses force. And it's titled the Maine State Police Use of Force Report. So that's our data collection tool that we use. That information is submitted as I had talked about, to the sergeant and then to the lieutenant of the troop and then to the training unit. That all has to take place pursuant to policy within 72 hours. So that one is just an example, and you'll see it says entered by Sergeant Chris Tupper. There's no additional information in there, but in order to start this process so that it works online, somebody's got to enter it, and that's the sergeant that works in the Office of Professional Standards that oversees the investigation. It's pretty detailed, it's pretty thorough, so not only is it tab forward, a narrative gets included in that, and I wanted you to have an opportunity to take a look at that. Additionally, the next tab, what I included was the Maine Criminal Justice Academy's model policy on use of force. And you'll see that that is titled the Maine Criminal Justice Academy Board of Trustees Minimum Standards Policy 1, Use of Physical Force Policy. Pursuant to statute, law enforcement officers have to have policies that meet the required policies by the Board of Trustees at the Maine Criminal Justice Academy. So I wanted you to see what the requirements are, which I think is around a 9-page document. Let me take a look at the 7-page document, and ours is 22. So you got to have at least the minimum standards that are included in this policy, but you can certainly have more, and that's what the Maine State Police has chosen to done. But all of the minimum requirements are laid out in this policy. We have followed it in our policy and adopted those minimum standards. Now, one other thing that I think is incredibly important, when we take a look at this holistically and how we deal with complaints and how we deal with officers and how we deal with discipline, it really starts with a hiring process. We have one of the most vigorous hiring processes that I'm aware of for any profession on the planet, and probably one of the most vigorous in the state of Maine. So once a person makes it through, has to jump through all these hoops that include a background check, that include things like an applicant oral board, that include a polygraph, that include screening committees, that have medical assessments, that have psychological assessments, all of those things. Once those take place and we hire someone, there's still significant training. And just because we hire you doesn't mean that you make it through training. So I wanted to just give you some numbers. You don't have these, but I wanted to provide them to you. We look back the last 4 years, and we've had 799 people that have applied to become Maine State Troopers. We hired 166 of those people, which is 20%. We graduated 119 of those people, which means we end up hiring and graduating 15% of the people that apply to become Maine State Troopers. Not a lot of folks make it through our process. Looking at those numbers. So from the 166 that we did hire, 47 of them didn't make it through hiring, or at the end of the training, there's a field training period and then a probationary period. They didn't make it through the whole process to become Maine State Troopers that work by themselves, which are pretty significant numbers. In that last bullet under training, what I wanted to provide for you was the training that Maine State Troopers go through. They all have to start at the basic law enforcement training program at the academy, at the Maine Criminal Justice Academy. And during that training, they have 84 hours of use of force and MARC, which is mechanics of arrest, restraint, and control training, in about 21 different scenarios. Then the Maine State Police take all of our folks for trooper recruits, and we bring them to our advanced training, which is now an 8-week program. We've experimented. It's been 10 weeks. We were down to 6. We're back to 8 weeks for this next class. Well, they'll receive an additional 80 hours of use of force and MARC training to include about another 20 scenarios. And our next recruit training troop, based on some things that we've identified and the fact that we're going back from a 6-week academy to an 8-week academy, we're increasing those instructional hours from 80 to 102, and we're increasing the scenarios from 20 to 26. And then since 2020, that next bullet down is all troopers have also received the following training. So whether you were someone like myself that joined the department 28 years ago, or someone that was hired in the last 4 years, all Maine State Troopers had to go through the following training. That's situational use of force, 1 and 2. That's a 2-hour class. We had to go through de-escalation training, 1 and 2, 2-hour class. Crisis intervention, 2-hour class. Mechanics of arrest, restraint, and control, 3 different times, 4 years each. And the MARC 4 will be held in 2026, and that's going to be an additional 4 hours of training for all Maine State Troopers when it comes to just the use of force. So that's the information that I was hoping to get out, but leave enough time for questions if there were any.
Oh, thank you. Thank you very much. Are there questions? Representative Milliken.
Thank you, Madam Chair. I'm sure you can't comment on like a pending civil issue that you have right now, but the incident that happened down in Limerick, I think it was, the Mr. Savage who was beaten while handcuffed. The officer who was alleged to have beaten him while he was handcuffed was promoted during the period that you guys were doing your internal investigation. Is that typical?
So we're not going to discuss any active litigation in any way, any case, whether it's that case or anything else more specific. We're here to discuss policy and process, and happy to do that. And I appreciate the question. I understand where you're coming from, but that's not something we're going to be able to address at all.
Are there any other questions? Representative Hasselfuss?
Thank you, Madam Chair. So, and I'm not sure, I do really appreciate this flow chart. I think the flow chart is super helpful, but, my question is when at what level does the use of force need to rise? Or what circumstances would state police refer something to supervisor versus the Office of Professional Standards?
So all cases that the trooper submits do go to the supervisor. So if they use, again, any amount of force other than compliant handcuffing, that reports get submitted to a sergeant, then to the lieutenant, then to the training unit. If anywhere along that line, any one of the supervisors that's reviewing that believes that there's a violation of our policy or believes that there's a violation of law, in other words, if it's a use of force complaint, you think that the force was excessive, then they're required to report that to the Office of Professional Standards so that we can investigate it from the Office of Professional Standards perspective.
So that's when it goes up the chain. And if it doesn't rise to that level where any of the supervisors up the chain feel that it is misconduct, for lack of a better term, then it would not make it to Office of Professional Standards. Is that correct?
That is correct. If none of the review process indicates that there are any areas of concern, it would not be reported to the Office of Professional Standards for an investigation. However, the report itself does get archived at the Office of Professional Standards. Part of the process that I didn't mention is trying to be brief is the audit portion of what takes place in our Office of Professional Standards. We added a sergeant last year, and I talked about her in the introduction. In her sole focus is to do audits and to check things at the troop level, to take a look at reports, to take a look at videos, to look at evidence lockers, to look at all things that law enforcement officers have to do and try to identify problems before they ever become a problem so that they don't rise to the level of OPS. We can correct those with training deficiencies or equipment deficiencies and those types of things. So part of her responsibilities for audits is when a review is done of a troop, every trooper has videos, body worn camera and cruiser cameras, videos that are reviewed by her. But she also takes the opportunity to review use of force reports that are archived within as kind of an overall safety balance, where if there's been nothing flagged along the way and no complaint made in an audit, she may very well pull a use of force report and say, hey, here's something that I'm looking at, and I think the Office of Professional Standards should review it from an investigatory viewpoint. Then that is a kind of a check and balance along the way, where that report, although no one along those lines from supervisors flagged it, the audit in the Office of Professional Standards can say, I've got some concerns with this. So that's another way that it could get into the Office of Professional Standards for an investigation.
And those are internal ways, right? So you could still get an external complaint from somebody that was involved that could immediately go into professional standards. So,
and then I do have a couple more questions. One is, the supervisors that are reviewing this, essentially I'm looking to see what's the impartiality level like? So, the Office of Professional Standards, does it separate individuals that are in particular units, or, how do we sort of ensure that the people reviewing the process are impartial? And the commissioner mentioned it before, with sometimes in the more rural or smaller agencies, they might refer it out. How do we make sure that there is impartiality when reviewing? Because as much integrity as any individual might have when you're investigating your friend, it's just might have the same feeling, or even if the investigation was done 100% proper, the perception may be there, that there might be some bias. So what does the state police do to ensure that there is impartiality with this review process?
It's a great question, and it's always going to be challenging because we are expecting people to follow our policies and to take a look at their training, education, experience, apply what they've learned in their careers, apply Graham versus Connor, apply our policy, and to make a judgment call on whether they think there is any areas of concern. What I can tell you is out of the complaints that were submitted during 2025, 21 of them were complaints submitted from inside the agency, not from outside the agency. We hold our supervisors to a very high standard. There are cases, not use of force, but there are cases when a trooper is investigated and disciplined for misconduct, the supervisor is next in that line. Our supervisors have an understanding that they have a responsibility to do the job and to do it correctly. They are not friends. Their job is to uphold the agency standards and to help us to reach our overall goals and objectives. And if they fail to identify an area of concern that is clearly obvious to the next level up, there's going to be, concerns with that, which is why it doesn't only stay within the troop. It's got to go for an independent audit or review that's being done by the training unit with our content matter experts who don't have that affiliation with the troop or the responsibility to supervise that person on a daily basis. So we think our process is very robust. We think that as long as there's humans involved, there is always that opportunity that there's going to be a mistake in judgment or an error along the way. But we think the checks and balances that are provided further down that chain, along with that overall audit process, along with the fact that citizens make complaints, as the Commissioner Sawchuk had said, we do receive complaints from members of the public, and those are investigated. Those 21 internal complaints, those are not use of force complaints. Those are total complaints where someone said, we think a trooper violated our policy or was engaged in misconduct or something similar to that.
No further questions? Yeah, the final question I have is the committee to review the use of force. Is that, can you explain that committee? I saw somewhere that there was a committee that was set up to review the use of force, but it has not been meeting regularly. Can you just explain that for me?
Sure, I can. So that policy M1 that you're taking a look at, that's the guiding policy that we use. In 2022, the prior administration had added a portion of this use of force policy that required the incidents where there is a use of force to be reviewed by an internal committee. We modeled it after our pursuit review committee, which reviews every pursuit that the Maine State Police is involved with. We quickly learned that we didn't use the correct model. We have about 30 to 45 pursuits in Maine annually. We are now receiving 150 plus use of force reports because we require them for everything. We quickly found out that we did not have the staff in place to successfully review them in that manner. And we also felt that because of the checks and balances that we have in place and the fact that we added a sergeant to the Office of Professional Standards to do nothing but audits and work us towards EMLI accreditation, that we didn't need the committee. So that committee is no longer in our policy. That was a self-guided policy that we imposed on ourselves, and we removed that from our policy because we weren't following it ourselves. And we don't want to have things in our policy that we cannot meet the expectation of, so we removed it.
Thank you. And so setting that aside, so it's just the refer to supervisors and then make the referral to the professional standards committee if necessary. And there's no, and then the audits.
Yes, sir.
That's the, okay. Just curious too, if you could get a few audits to us just to review, it doesn't have, just saying, with the thought being the idea of oversight is to try to identify problems before they happen, which I appreciate that in a lot of this you've said, like, that's what the state police does. You try to predict what's going to happen, identify that problem, solve it before it happens. And I greatly appreciate that. And so I'm just curious if you can give us some examples of, what the audits do, how they try to find problems that haven't yet arisen, how that's happened, what the solution has been. I'm just kind of curious to see if there's some, just couple of bullet points on things like that that have happened over the past and how you're constantly trying to identify problems and solve them before it gets to the complaint level.
Yep, absolutely. I can get something together on that. It's a relatively new program for us where the sergeant, I think, started in September with us and unfortunately was out of work for about a month with an injury. However, we did complete an entire troop and have done some random audit items along the way with other troops also. So yeah, I can come up with some information on that and get it back to the committee.
Thank you very much. Are there any other questions? Thank you.
Thank you for having us. We really appreciate it.
Well,
Yeah,
we
greatly appreciate it. Have a
appreciate
good day.
all the information. Thank you. We are going to take a break and I don't know quite how people are going to deal with lunch or anything. And maybe you brought lunch. I don't know. Is the cafeteria open yet? It is open now. Oh, okay. Good to know.
We're scheduled to be back.
We're scheduled to be back at 1.
We'll just be a few minutes late.
Yeah, we are. We're actually going to move the 1 o'clock time to 1:15, if that'll work for people. Okay,
Get
so,
out of the room here so they can.
Thank you.
Thank you very much. See you later.
so at 1:15, we'll come back for our 1 o'clock.
You can kill the rest. The Westwood one.
Yeah.
Yay.
How come it doesn't kill mine? So we're going to start the meeting. A presentation, the Office of State Fire Marshal. A report on authorizing municipal fire departments to conduct sprinkler plan reviews. If you would like to give us the context, and thank you.
There we go.
Very
Senator Beebe Center, Representative Hampton Fuss, honorable members of the Criminal Justice and Public Safety Committee. My name is Sean Essler. I am currently serving as the State Fire Marshal. Beside me is the Assistant State Fire Marshal, Greg Day, and we're here to present on LD 1005, which was an act to allow municipal sprinkler review. If you remember correctly, it was presented as an LD and later turned into resolve to direct the Office of the State Fire Marshal to convene a working group and to study municipal sprinkler plan review. The committee specifically required the working group to examine 3 different areas. One was the status of the sprinkler plan review. The second was the best procedures to allow for municipal authorization of sprinkler reviews. And third was to address the strategies to address State Fire Marshal's Office staffing needs. We interpreted the status of sprinkler reviews to be the number of sprinkler review permits issued annually, the time required to issue these permits, and the use of our temporary or preliminary permits. The second item on the list, the best procedures to allow municipal authorization, we specifically looked at areas whether municipal fire departments could safely and consistently conduct reviews, what qualifications and oversight, and how statewide consistency would be preserved. Specific to strategies to address the office, we talked about timeliness in the working group, staffing alternatives, and ensured the committee received options, not necessarily just a single solution. So that was kind of the purpose of the report. Now, I'm going to take you on a little bit of a journey because this report is very lengthy. But in the interest of time, I'm going to try to give you just a very broad overview of the report. So the working group included the State Fire Marshal, members of the Maine Fire Chiefs Association, Maine Municipal, other municipal fire chiefs looking to perform sprinkler review. We added some industry, sprinkler industry professionals to have a voice as well, and municipal fire chiefs from across the state representing both career and volunteer departments. It was incredibly important to us. Page 2 represents an executive summary of our project, and page 19 outlines all the members of the working group in particular. I think before we examine the questions that the committee put forth for us, we needed to understand what the baseline or the reality of the fire marshal's office was. Specifically, pages 8 through 10 involve the background and the current operations of the department. Pages 13 through 14 identify what a plan review actually is. And because each of these topics are extensive, I'm just pointing you to those various sections at this point. Page 28 of the review, and again, this is a journey, talks about specifically the sprinkler review data that was captured from the office for you folks to examine. Maine currently operates a centralized statewide sprinkler permit review system through the State Fire Marshal's office. I think we established that last time. We, through the numbers, recognize that our plan reviewers are handling about 1,600 projects annually. That includes sprinkler projects, just under 800 that we're going to do in what we've done in 2025, and about 800 construction projects. I testified last time that sprinkler permits, there wasn't much of an issue because they were issued temporary or almost immediate
authorization to work through a temporary permit. And it's important that we also note that the current system that's in place was completely self-funded through the fees that's generated through this process. So again, what is a plan review is important. That's on page 13 to 14, and some of that data is toward the back in the appendices. So the committee took it upon itself to identify what is the real problem surrounding the particular issue that was raised. And the data shows 100% there is not an issue with sprinkler reviews as it relates today. The issue as it relates to delays in the fire marshal's office were specific to construction permits. That is a different process within the fire marshal's office, but understand that a construction project can also have a sprinkler permit as well. So testimony from the industry stated that the fire marshal's office was some of the fastest in New England. And the core issue that the working group really dove into was capacity, the capacity of the office to conduct both sprinkler and construction reviews, not necessarily who is doing them. Of course, we dove into that as well. So we tried to go above and beyond by creating on page 16 an efficiency analysis of the office. We noted testimony from the sprinkler industry on page 9. And the biggest note or highlight that I want to provide is this wasn't a sprinkler backlog problem. It was a staffing and capacity problem with construction permits that really is the root cause of the issue. We looked at municipal capacity across the state, and we recognize that there are a few fire departments that can do sprinkler reviews. Matter of fact, a couple of the communities are behind me today. We have representation from both Portland and Waterville here, if you have any questions for them. We tried to determine how many people possessed the necessary skills across the state to do this. Unfortunately, the database that NFPA maintains was not complete. So we were able to capture that there are about 30 individuals across the state that are certified to do plan reviews, and half of them are in the fire marshal's office. We recognize that most municipalities do not have the volume to justify building or sustaining a compliant program. And there was a couple comments regarding, fire departments and EMS services are struggling to deliver basic services, let alone dive into plans review. However, the committee does note that there are a few fire departments that could have the capacity to do municipal review. So just getting into the recommendations of the crew, of the working group, on page 4. One of the recommendations was to strengthen and sustain the centralized plan review function. The working group unanimously recommends that the state fire marshal remain the central authority for conducting sprinkler reviews. This ensures the uniform code application, a single point of enforcement and licensing, and reduce municipal liability. So things like modernizing the electronic or the agency licensing management system we call ALMS would certainly improve the service without fragmenting an issue. The second recommendation that again is supported unanimously is to expand the capacity of the fire marshal's office. We talked last time, the committee, about the capacity issue. We identified that it was a capacity issue. And the committee put forward a recommendation of funding 2 positions through dedicated revenue and 2 positions through general fund. A part of that efficiency analysis on page 18 through 19, which I can dive into a little bit here,
16 through 19. Provides a little bit of insight as to the current workload of the plan reviewers, which if you divided approximately 1,600 projects by 4 plan reviewers, you come out to roughly 418 projects each. That's better than 1 project a day if you divided it over a year. Some of these projects are substantial. So you can see that the workload on the specific plan reviewer, because of the increases in the economic development of Maine, have far outpaced our capacity in the office to perform services. So just conducting simple mathematical formulas, we were able to come up with, if we hire 2, we have a 33% reduction in workload amongst current staff. If we hire 4, we have a 50% workload reduction in the office and allow us to do more capacity. Using simple mathematic formulas, we were able to take the 6-week timeline with adding 2 reviewers down to a 3 to 4 week timeline and adding 4 reviewers down to a week and a half timeline. And it's important that we note that this would service the entire state of Maine, not just one community. It's important. I've already pointed it out, although I didn't highlight it, but throughout this document, we wanted to identify what the plan review actually consists of and what the collateral duties of our plan reviewers are. And the duties of a plan reviewer are significant as it relates to the office. Public education, technical guidance, field inspections, amusement ride inspections, supporting fire investigations at emergencies, training and professional development, data and quality assurance, and interagency cooperative efforts above and beyond just simple plan reviews. So again, back to recommendation number 2 was to add staff to the fire marshal's office. Now, with that said, I, as the fire marshal, need to be clear with the committee. I have not been involved in the administration's supplemental budget. So while the working group does recommend additional staff and identified 2 areas of funding, I don't know what can and cannot be done. I just want to be clear with the committee that I haven't been involved in the supplemental budget process. The third recommendation is to establish a framework for municipal participation. We were able to come up with a consensus in the group that there are communities out there that are capable of performing both plan review and sprinkler review, but the working group agreed that fragmenting the current system should be done very narrow in a controlled, pathway. So municipal participation should be optional. It should not be required. It should be governed by a formal MOU so the agencies working together can have clarity on what positions each other is going to perform. And we identified that it certainly should be performed through, by people with specialized training. One of the things we did highlight in the report is that we needed these folks, and the committee the working group agreed that these would be they should be municipal employees and not contractors. And what I mean by that is a municipal employee that's vested in fire prevention, that's not for hire, essentially, to fragment the office. Does that make sense? So we noted in our report, it should be an employee of the agency and the community should be invested in fire prevention, likely an employee of the fire department. They should be a certified plan reviewer. And we've identified, I believe in a subsequent recommendation, that we should use a centralized program for all contractors to access across the state, whether you're doing a state project or a delegated review, the process becomes the same. It uses the same electronic application process. State Fire Marshal's Office would retain the authority to create rules, revoke delegation if need be, and retain jurisdiction over the high-risk occupancies like daycares, healthcare facilities, the stuff that requires additional training above and beyond the average review. So the working group put in a lot of time, and I should have mentioned this right to the beginning. This was every single week the working group met to come up with this expanded document that I hope meets the needs of the committee. On pages 24 through 26, you will see that we added a MOU for the committee to review. We didn't just want to talk about it. We wanted to put some language in front of you so you guys could review that for yourself. Now, we're not saying that's the final product, but there's an MOU there that you can see models what the relationship between the fire marshal's office and the municipality could look like. We also, I'll get to that in section 5. So moving on to recommendation number 4, we felt that if we partnered with municipalities, that one of the major issues that code enforcement officers are facing across the state right now is that they're not being overly supported with continuing education and good, strong communication. So we felt that if we were going to delegate, for example, behind me, the city of Portland and the city of Waterville, we wanted to create a training, a more tight net relationship between the fire marshal's office and the communities, and do a quarterly meeting / training, basically to increase statewide certification, quality assurance, maintain consistency in code interpretation, and ensure, a good interpretation codes across the entire state. So we would propose, a quarterly meeting or training with our delegated review communities. Recommendation number 5, we noted that there were a few changes in statute that would need to happen in order to allow this to be done. So we work with the Attorney General's office to provide on page 21 through 23 the amendments to the laws specifically that would allow municipalities to do sprinkler reviews under an MOU, under the guidance of the fire marshal's office for the committee to review. We wanted to make sure that we came forward with a solution that was ready for action, should you choose to take up this issue. And that was recommendation number 5, statutory and administrative updates to enable modernization. The other item that I need to point out is the fire marshal's office has already begun work on what's known as the ALM system, the Agency Licensing Management System, to allow municipalities to use the state system to receive permits. So we've already started that process, and all we have to do is turn it on should the committee agree to move forward with the legislation. Recommendation number 6 is using that ALM system. We also want to make it publicly transparent. So we want the public or the person that has applied for the permit to be able to log into the system and see the status of their permit at all times. So we want to expand the use of that ALM system to improve visibility and application status, and to provide an annual report available to the public on volumes, timelines, and participation. We think we can do that to be more publicly transparent with our permit review process. And again, the key recommendations that we have really broke down are on page 6 through 7. We must talk about the costs. Adding personnel is not cheap. So on page 30, we have outlined the cost of the reviewers. On page 31, we've added information specific on how the fire marshal's office is funded. We wanted the committee to understand where the fire marshal's office receives its funding, and a very small portion of our overall budget actually comes from the general fund. Most of it is a special revenue account. And we've also included a chart in here for transparency that shows all the revenues of the fire marshal's office and what accounts for sprinkler reviews and what accounts for fire premium tax and what accounts for other charges and fees in the fire marshal's office. The last item, which is the last page, which is page 33, is we realized that even working every single week as a working group and putting this team together that come up with this consensus, there were still items that we just could not deliver in the short timeline that we were given. One of them is we understand that fees do need to be addressed at some point in time, but the working group also understands that raising fees today and with, you know, with the economics that are on the shoulders of our contractors may not be of the interest at this point. And we recognize that, so we intentionally left out a fee discussion out of this structure. The other thing that we intentionally left out was limitations to the statutory review. We just need to understand that this doesn't give us the authority, the fire marshal's office, nor the municipality to review everything. There's only a certain amount of projects that are reviewed under state statute, and we've included that in 1005 for you to review. So I know that that was a flipping back and forth, long journey. But I do think that LD 1005 was responsible. It was to send it to resolve and to assemble a working group so that we could bring back information. I'm glad that the committee did not take a vote prior to. I want to thank Chief Sloan from Westbrook, who initiated this discussion, and Representative Lookner, who brought it forward. And again, the committee for just taking a pause and letting us do a little bit of work on it. The working group, some of which is behind me, and the delegated review communities were instrumental in putting together this report. I hope that it's provided you with some information. And again, I did not try to get into the weeds here for the sake of time. So I'm happy to answer any questions anyone may have.
Representative Perkins, do you have a question?
Thank you, Madam Chairman. I have a couple of quick related questions, if I may. Thank you, Mr. Ursula, for being here. So you said you could identify that half of the people that were capable of performing these inspections were in the office. So you must know where the other half are. Is that correct?
Yeah, so
roughly where they're at?
Yes and no. The database for NFPA was incomplete. So with that being said, we estimate based on what we know in the office that there's more than 30. We just don't know exactly what that number is, whether it's 54, whether it's 44, we don't know.
Okay.
But half of the people listed on the NFPA's website work for the fire marshal's office, and probably the other half are sitting here in the audience.
So the reason I asked that question is, so outside of Portland, outside of Waterville, are there other departments that you know of that would have an interest in doing it themselves? For example, with Bangor or Saco or Biddeford or Brewer or some of the, any other, are there, outside of those two, are there other larger municipalities that you're aware of that would be interested in doing it themselves, or just those two?
No, I'm aware. I believe the town of Skowhegan is interested at this point. I know the city of Westbrook is interested at this point, and I believe there's another southern community out there that's interested. So this is not a,
and I had those qualifications that had those people qualified?
I do believe that they would have those people qualified, and if the law was enacted the way we propose, it would prompt an MOU and a little bit of oversight from our office. We would control essentially the process at which people apply, and we would help them in onboarding and continuing education and training. And quite frankly, it would probably be a great relationship moving forward.
So out of those, especially with Waterville and Portland being being such large communities in our state, out of the 768 that you list here as being current work projects or the average work projects for specifically for sprinklers,
what percentage would those two communities make up out of that 768? For example, you're not gonna have hardly any sprinkler systems installed in Bower Bank or a BB or something like that.
Sure.
But you're probably gonna have quite a few in Portland, quite a few in Waterville. So out of those two communities, or out of those 4 or 5 communities that you identified, what percentage of those would make up that 768? Are we talking 20%, 30%, 40, 50% of the sprinkler projects that you
estimate that?
anticipate? Because that would make a big decision on looking at this funding. I mean, you're looking at $700,000 for 2 additional people, you know,
It would be a very small percentage.
a small percentage. What's a
Other
small
than
percentage?
Portland, which is a busy community. I do not see a really large percentage of Skowhegan and Waterville at all.
Okay, so what about Portland? Is that 10%, 5%, 20%? Did someone tell me? And if you can't, that's okay. If you can just send that number back to us at some point.
Yeah, Representative, we'll get back to you on the
Okay.
specific numbers that it would take. Portland is, they can speak for themselves, of course, if you have specific questions for them, but they would certainly be capable. There may be some, I have heard from the other delegated communities, including Waterville that's behind me, that they have no interest in conducting sprinkler reviews.
Okay.
However, they do have an interest in continuing the delegated review process and strengthening the relationship between the fire marshal's office, which is what we're proposing here. And again, you can ask them directly, but so we do see it as a small percentage, but we'll get
Okay.
the numbers for
I
you.
appreciate that. Thank you, sir. Thank you, Madam Chair.
Senator Zerway, do you have a question?
Yes, thank you, Mr. Chair. Years ago, on this committee, the commissioner brought forward a request to raise the, put a percentage fee for each plan, each project. And I didn't know what your thoughts were on that. And I know he was talking like, I think it was like 7% or something. It was a pretty high figure. And I didn't know your thoughts.
I think 7% is incredibly high. And I think that would, cause a problem with a lot of developers.
Well, it did.
We currently charge 0.0015%.
Yeah.
For plan reviews, which is a tenth of 1.5%. Correct? So, and if you look on page 32, you can see that the construction review process generates last year 1.4 million for the fire marshal's office.
Right.
So the construction permit review is significant. The sprinkler permit review last year was, well, about 10%, so 140,000. So that number is very, very small as it relates to the loss of the, of revenue of the fire marshal's office. Now, if you remember my testimony, I'm concerned that if we just broadly say everybody can do this, we lose our funding mechanism.
Right.
And the office no longer functions the way it has for many years. But a narrow, focused, under the idea that the state and municipalities can partner together, the loss of revenue is smaller, but it provides for a very consistent interpretation of codes and the enforcement of codes, essentially. So we feel like there are some communities out there. We have compromised to the fact of we're willing to support, not only support them like we do today, but we're willing to provide additional support for these communities so that we don't come back and say we fractured a system. This is terrible. Every code enforcement, every fire inspector in the state is looking at things differently. That's not, we don't want to create the problem that exists in the code enforcement realm today.
Yeah.
We want to support our communities. We want to support their idea of home rule, doing things efficiently. And if their communities want to contribute to fire prevention, then they should be allowed to do that.
Well, I appreciate it. It's, we was fighting that battle before, and it seemed like, a lot of times, like we'll say a school, a lot of the schools have the same, almost identical build. And all they have to do is look at another one and say, yep, this pretty much matches that. That's what we need. And, but they wanted this high percentage of money. And I said, it didn't make much sense, but the way it just approached it makes more sense. So do you think by raising a little percentage, just enough to get the extra manpower you need to do that is what the answer is?
The answer is anytime you add a fee,
Yeah.
we certainly could use those fees to offset the cost of personnel. That is correct. We recognize that raising those fees creates an additional burden for the contractor.
Right.
So that it's always a balance. The fees in the fire marshal's office have not been adjusted for over 20 years. And the reason why they haven't been adjusted is because the fire premium tax that we receive in the office, the $6 million a year that's illustrated in this revenue for the fire marshal's office, is based on a small percentage of residential fire insurance. And because the value of property increases over the years, that fee has remained the same, a percentage. So as property values have increased, you can see based on the chart that fire premium tax has increased and therefore has been able to support our office all of these years. And we also went in years that we have less expense than we do revenue coming in the door. The law allows us to set those funds aside into an account and utilize that account for capital expenditures, fire prevention, or items that the office requires to function on a daily basis. So there is some funds in that account that's available, which is why the working group chose to say 2 people can be funded out of this special revenue account.
Okay. So you just need the okay to do it.
I would, I can't venture out on a limb and say that the administration, supports it because I haven't seen the supplemental budget. But
Yeah.
if you're asking me, do I have the funds available to support 2 positions? The answer would be yes, we do have the funds to support 2 positions. And clearly, the funds generated from plans review are paying for the plan review division today.
Okay, thank you.
Are there other questions? Yes, Representative LaJoy.
Thank you, Madam Chair. Thank you for this report. This is such a critical report that in all my years in the fire service, I have wanted to see. The collaboration between all the individuals here is outstanding. Thank you. My other thing is on the fees, and you're talking about the contractors. Wouldn't the contractors be able to, of course, charge that fee to the builders, the owners, or what have you, as a portion of the cost of the project?
Yeah, ultimately, I think the better word for we have architects and engineers that are applying for our permits and they're paying the fees. And to be honest with you, they're passing it off to the customer. So the builder, the person that's deciding to build this public building, the customer, whoever that may be, that fee is going, directly to them. We're not, I don't want to sugarcoat it, or that's where the fee ends up is on the builder. So, I think that fees, again, we did not analyze fees in this working group. We intentionally didn't analyze fees because we knew, number one, the economy, and number two, there's a lot of conversation to be had around fees. And we just didn't feel like that was the charge of the committee at this moment in time. So we felt like that was a separate issue that we really needed to stay focused on. Can we create a pathway for municipalities to conduct sprinkler reviews or not? Those were the 3 questions that were asked. We think we provided a tremendous amount of information here above and beyond that. And we intentionally omitted fees for that reason.
Yes, follow-up question?
I agree with you. You have, there's more information here. I read through every page actually. I was extremely happy as to the results. And I'm very positive. I will look at this and the recommendations very seriously, and in a very positive manner. I think it's extremely important. Getting back to the fees, we're doing that throughout the United States today. Whatever we raise, the consumer pays for. And therefore, it would be really nothing different. I'm not pushing that, but I'm just saying that is part of life in today's world. And if it has to come to that, and the fee is not that huge an amount, I think it would be absorbed, not without complaining, but I think it would be absorbed as a cost of doing business. Just think about that and with the committee as well, if you will. So thanks again. It's a great report, and thank you.
Are there any other questions?
Quick question.
Representative Hassenfuss?
Thank you, Madam Chair. So you mentioned in like your first sentence that the sprinkler review is not really an issue, but the construction projects kind of are, what maybe is being slowed down, what could use some help. So what are your thoughts on how best we can, address that? Does this report cover everything, or is there more stuff we should deal with related to construction projects?
This report had to pull in the entirety of the plan review process. And if you read down through it, that was my point, is I wanted to be sure that some of the backlogs that are highlighted in here are specific to that construction process. There are notes throughout, but I just wanted to make sure that was highlighted. This really is a capacity issue, period. End of story, hands down. This is a capacity issue. Over the last few years, exacerbated by COVID, development has doubled. The value of projects coming through our office has gone from 900 million to $1.8 billion. It's doubled in size, I believe was my testimony last time I was here. What hasn't doubled is the capacity of our office. It's just that simple. So we've done a good job for a long time. Nobody's questioned the quality of work out of our office. Nobody's questioned we get very, very few questions from the public. They understand the process. They know what to expect from the fire marshal's office. We just simply don't have enough bodies in the office to process every construction permit in a timely manner, which results in that 6-week backlog, which fluctuates. Sometimes we catch up. And during COVID, unfortunately, I'm here to admit it was 12 or 14 weeks. That was painful, very painful. I was the fire chief in the city of Waterville during that time. Development was trying to take off during COVID. We were waiting 12 or 14 weeks for the fire marshal's office. Guess what? I became a delegated review community, just like the gentleman behind me. So I understood what it meant to my community to get projects moved faster. Looking back on it, I now understand I did not have the expertise of the fire marshal's office. Okay. But we learned and earned that expertise through, doing plan reviews. So as the state fire marshal, I'm ready to turn around and support Waterville and provide them more assistance than they've ever had before, and more clarity than they've ever had before on the positions of how each other is going to operate, and more support as it relates to online and electronic application processes. So the fire marshal's office, we're ready to go, and we're ready to support these communities, and we're good with delegated review. We're good. We think this is a good thing for the fire service as a whole at this point.
And you mentioned the capacity issue, maybe slowing some projects down. Do you know what the potential finance, do you have any, I know you didn't get into the finance, but do you have any gauge on what the potential financial losses for those projects are when they are delayed? The thought being, if you increase fees slightly, but speed the process up, perhaps it's a break-even point there somewhere where you get it built quicker, you get your revenues quicker, and yes, your fees might be up, but at the end of the day, everybody's actually making money in such a circumstance. I'm wondering if there's a point there that we could identify.
We're not opposed to raising fees. We're not opposed to that. But we want to be very transparent in the realities of raising fees, which you guys deal with every day, you know? So we just feel it's a bigger conversation. There are many areas of statute that would need to be addressed to talk about fees. But if the committee wants to take up a discussion on fees, that discussion would also benefit the delegated review communities because then they would be able to charge those fees to support their processes as well. So it would be a good conversation to have, just we didn't cover it.
Representative Perkins?
Thank you, Madam Chair. Just as a comment, but the fastest growing cost in new building is the regulatory costs, that setback fees, delay costs and all of that. So just by adding planners, you're going to lower the cost for any developer by just speeding up the cost. You're not raising their costs, you're lowering their costs. So if you cut their wait time in half, you're lowering the cost of building.
Yeah.
And then that wait cost is a regulatory cost, which is again, the fastest growing cost in building. And I mean, we're talking, what do you say, 140,000 was the cost
For just sprinklers.
for just sprinklers, so 140
1.4 million for construction.
for construction, but I mean, you're talking 140,000 and 760. So you're looking a little less than $200 a pop for those inspection fees. So it's not a great fee, but I mean, so raising it is not a huge issue. I don't think going from 200 to whatever's other small number, but just adding these inspectors is a great boon to our builders, our construction industry. Because just like I said, just lowering that wait time is a huge savings to developers. I just want to make that comment.
Senator Searway?
Thank you, Madam Chair. So my understanding, I just wanted to make sure I got it clear that we don't really have to raise prices because the economy is raising it anyway because of your percentage, right? I mean, you're getting higher values of housing or buildings, and so you're getting the increase that way, correct?
So we're talking about the fire premium tax.
Right.
Yes, the fire premium tax, property values are increasing, therefore the amount that's funding our office also is increasing. We do have that cash reserve that certainly could
Right.
cover those employees without raising any
Right.
fees at this moment in time.
That's what I'm saying, yeah.
But for sustainability, long-term, fee discussion is not off the table.
Right.
And I do agree that there would be some support from the building industry on raising fees some if they're getting the value of raising those fees.
Yeah.
And the value here is the speed of which those projects being done. So imagine that you're building a $100 million building in the state of Maine, and you could get that down to a 2 or 3 week building, review permit. Of course, that's going to take a longer review just by the nature and complexity of the project, but that would be incredible. That attracts business to the state of Maine.
Right.
Yeah.
Are there any other questions? Representative Hassenfuss?
I don't have any questions, but I'm thinking what we should do is, because this resolve had the ability to report out a committee bill, I think that we should try to take a committee vote on whether or not we should refer this to OPLA to draft a committee bill to then set for a public hearing.
Well, we're going to have our legal analyst come up after we ask the questions and sort of offer the next steps to us. Okay?
Yeah, no more questions.
If there are no more questions.
And I don't want to overstep, but I encourage you to ask questions of the 2 delegated review communities behind me. They may have some insight or, for you that I haven't given you.
Yeah, and if we do a committee vote on this, there'll be another public hearing once that legislation is drafted, at which time it would be opened up for more questions on the proposed legislation and such of that. So this will not necessarily be the end of the discussion, so to speak.
Thank you very much. Well, we want to come. So we're going to invite our legal analyst, Will, to come up. Sort of summarize and point us in the direction. Next steps.
Yep. So I'll just piggyback off of Representative Hattenfuss, what he was
Sure.
explaining to the committee. It's been a while since we've done a committee bill. I think the last one was LD 1980 last session. And this is first of many reports we'll be receiving that have authority to report out legislation. So as Representative Hattenfuss said, this did have explicit authority for the committee to report out legislation. The committee will take a vote on that. It's strictly procedural about whether the committee would like a bill drafted containing the material within the report. Just because you are voting to have a bill referred out doesn't necessarily mean that you agree with everything in the content of what the bill will be. It's really just you agree that there's potentially some merit to this and it should come back to the committee for further discussion. You might ultimately vote ought not to pass, or maybe you have an amendment to it. But it's not necessarily right now that you're agreeing with the bill by just having it referred back to the committee. On that note, it's also not necessarily the only option in terms of what the next step is. That's by far the most common, is if a bill is reported out by a committee after a vote, that it would come back to CJPS so that we can go through our standard procedure of having a public hearing and a work session. Sometimes bills are referred directly to the floor as provided in a presentation, or in some unique instances, there's a public hearing. It's almost like a preliminary public hearing on a report to determine whether there should be a bill that comes from this. But like I said, those are typically uncommon, and the most common path is that the committee just votes on it. It'll be reported back to the committee, and we'll go through our standard procedure of having a public hearing and a work session. So if that's something that the committee is ready to take a vote on today, we can do that.
Do we need a motion to do that?
Yeah.
Do I have a motion? Representative Hassenfuss?
Yes, thank you. So I'd like to move that we report out a committee bill that uses the draft language that has been provided to us in this report. Additionally, with that, I'd also like to see that bill has a proposed fee increase. This is going to be difficult, Will, but if there's any way to figure out where that mesh point between the right fee, where you're going to reduce overall costs essentially by getting the building up faster, if we can find that. I think some of that might have to be through discussion, but so just let's add a proposed fee increase also in that bill that we can then discuss at the public hearing. I don't know what the amount should be. Does anybody have any?
Probably doesn't need to be decided now. I think that's probably something that will be hammered out at a public hearing or work session.
Yeah. Okay.
Representative LaJoy?
I'd like to second the motion.
I'd like to second the motion.
Any further discussion? All those,
We can just do a show of hands. It's
just a
okay, we
show
don't
of
need it.
hands? All those in favor?
Yeah. Okay.
None opposed? Okay,
All right.
all right.
That concludes that. We can move on to public hearings. Let me get this back up real quick.
Okay.
Thank you for that report. Thank you for coming in. Sorry to make everybody come in and not a lot of questions, but we'll be calling you back. We'll talk about a month or so.
Thank you very much.
Let's just leave.
Right. You ready? Hello. I'm Senator Penny Beebe Center, and I'll be presiding over this public hearing today of the Joint Standing Committee of Criminal Justice and Public Safety. Purpose of this hearing is to invite testimony from members of the public regarding proposed legislation that is pending before this committee. The committee will hear testimony from persons present who wish to speak for, against, and neither for nor against the bills to be heard today, which are 2 bills. With leave of the chair, committee members may ask questions of any person testifying today. Other questions are not permitted. Whether or not you testify, you may submit written testimony to the committee. Please be mindful that testimony is public and is available to all once it is presented. Persons testifying at the public hearing today are advised that the hearing is live streamed and may be seen and heard by persons watching online, and that a recording of the meeting will be archived. Members of the committee, before I ask you to introduce yourself, I have several important items to address related to the format of this meeting. First, if you're in the room with us, please mute the audio and microphone on your electronic devices, including members sitting here at the Horseshoe. This will prevent audio disruptions both in the room and online. Second, for those joining using Zoom, if the name you used to sign into Zoom is not the same as the name you used on the legislature's website to register to testify, it may be difficult for us to identify you when it is your turn to testify. We will not close the hearing until we've given everyone on Zoom an opportunity to testify. If you're having technical difficulties, please call our committee clerk. Finally, all questions from the committee members must be made with leave of the chair. Could I ask the committee members to introduce themselves? And this will be part of the record. Would you like to start?
But of course, Madam Chair, Donnie Ardell, House District 6.
Representative Steve Bunker, District 75, Farmington and Chesterfield.
Representative Michael LaJoy, District 96, part of Lewiston.
Good afternoon, everyone. Nina Milliken, House District 16, Blue Hill, Brooksville, Castine, Sedgwick, Surrey, and Trenton.
Good afternoon, Senator Penny, BB Center, and I represent the county of Knox, except for Idaho and the town of Washington.
Representative Tavis Rock Hassenfuss, House District 57, Reedfield and Winthrop.
Good afternoon. I'm Representative Bob Nutting. I represent District 66.
And I'm Senator Scott Searway. I represent District 16, which is Albion, Winslow, Oakland, Fairfield, and Waterville.
Representative Mana Abdi, and I represent District 95, which is part of Lewiston.
Good afternoon, I'm Representative Chad Perkins, and I represent District 31, which is 7 towns in southeast Piscataquis County.
Thank you. Do we have anybody registered on Zoom?
I'm probably check. There's 2.
Have they offered testimony? Okay.
Christopher Reese is.
Does he have testimony?
I don't know which, he hasn't submitted anything, but he's
Okay.
in the queue.
Okay.
Would you like me to? Would you like me to move to vote for to see him? He's got to get the.
So if I could ask Representative Bunker. Who is this sponsor of both of the bills? And let's start with 2012. Does that work? Okay.
To the honored chairs and members of my committee, I'm Steve Bunker, District 75, representing Farmington and Chesterville. It's my pleasure to assist Department of Public Safety and the Office of the Fire Marshal in sponsoring LD 2012, an act to amend the law governing carbon monoxide detectors. I'm going to be very deft in my stepping aside where the real expertise sits behind me on this, except that in my many years as a firefighter, a member of the Fire Protection Services Commission, I know full well the threat and harm of carbon monoxide is to life and safety of personnel here. And you have seen the expertise from our fire marshal in the previous report that we heard concerning permitting issues. This is an example of his ongoing review of the program that he inherited and looking at existing statutes and where changes needed to be made. So I'm pleased to bring this particular bill up because it really deals with carbon monoxide detectors and making sure that our state harmonizes with recognized life safety standards themselves, particularly the NFPA Life Safety Code itself. And as our changes are made to the national code, we want to make sure it harmonizes with where our statutes relate to carbon monoxide detector systems in there. So this touches a number of areas, and I'm sure the fire marshal can expand on those issues. But it covers a number of important issues, particularly with how we identify the number of and placement of fixed smoke detector systems, particularly in schools and childcare settings that are very easy, and knowing that these kinds of complexes, just the location of one detector is not sufficient for broad expanded or multi-level kinds of facilities. This would address that issue itself. Also, I'm pleased to see that this requests an amendment. As you and I know, the Attorney General's office is responsible for death investigation, inspections, investigations and protocols. And this would add the Fire Marshal's office in their expanded role to help investigate with their expertise any areas where there's suspected carbon monoxide related deaths in that area. So you'll note in statute, and the fire marshal will brief us, I'm sure, those areas in state statute that require a tweak, if you will, to make us harmonized or in compliance with the life safety code where it applies with state statute. I would hope that we would support this issue, and I would be ready to answer any questions as brief as they might be.
Are there any questions? Okay.
Thank you.
Could I ask Christopher Rizzi to turn the camera on? Thank you very much.
Thank you. Good afternoon, Madam Chair and members of the committee. My name is Chris Brzee, and I'm testifying on behalf of the National Electrical Manufacturers Association, or NEMA, in support of LD 2012. NEMA is the leading trade organization representing America's electro industry and fire and life safety product manufacturers. As you just heard, LD 2012 ties carbon monoxide detector installation requirements to NFPA, or National Fire Protection Association standards adopted by the state of Maine. NEMA strongly supports this legislation. We believe this legislation improves protection of life and property in a cost-effective manner, in line with expert recommendations and existing standards. According to US CDC reports updated on carbon monoxide poisoning, it results in more than 100,000 emergency room visits annually. I apologize for my cat here trying to get into the frame, with 14,000 hospitalizations and more than 400 deaths. Carbon monoxide alarms and detectors listed the current alarm thresholds in UL 2034 are an important aspect of an overall carbon monoxide poisoning prevention strategy, and the vast majority of severe carbon monoxide poisoning instances occur in buildings without functioning carbon monoxide alarms. LD 2012 requires that carbon monoxide detectors must be installed in accordance with NFPA standards, including NFPA Standard 101, ensuring occupancies are properly protected from the risks of carbon monoxide poisoning. We believe this is a cost-effective way to reduce carbon monoxide poisonings and strongly support tying it to existing expert standards. We believe that the proper installation of these devices is also extremely important, making those NFPA standards key to the proper installation, keeping them up to date will be a great advantage for the state of Maine in preventing carbon monoxide incidents across the state. For these reasons, NEMA strongly supports passage of LD 2012 as written. We look forward to working with the committee to move this legislation forward and are happy to discuss this issue further with you at your convenience. Thank you for your time and consideration. And we did not have written testimony ready for today, but we can submit it to the committee at a later date. Thank you.
So you will be submitting written testimony?
If that's acceptable, I'm happy to submit a written copy. I just needed to get it passed, finalized for y'all. Thanks.
Okay, thank you. Are there any questions? Thank you.
Thank you.
Is there anybody else that would like to speak in favor of this legislation? Please, thank you. I'm sorry, went a little out of order.
No problem at all. I think we've already provided it. Well, good afternoon, Senator Beebe Center, Representative Hassan Foss, and honorable members of the Criminal Justice and Public Safety Committee. My name is Sean Essler, and I am the State Fire Marshal. I'm here today to testify in support of LD 2012, a bill that's intended to harmonize Maine's carbon monoxide detector statute with nationally recognized life safety codes. Carbon monoxide is colorless, odorless gas, and one of the leading causes of accidental poisoning death nationwide. LD 2012 makes targeted technical updates to ensure Maine statute aligns with the state's regular adoption of NFPA Life Safety Code, a process that the Fire Marshal's Office already carries out. Beginning in January 1st of 2027, the bill requires carbon monoxide detectors in newly constructed occupancies only where such detection is required by Life Safety Code, as adopted by the Commissioner. Under current law, the statute contains fixed occupancy language that does not automatically align with the current or the future editions of Life Safety Code. In practice, this creates an unnecessary administrative burden for the State Fire Marshal's Office, including the need to amend, remove, or strike outdated statutory language every time a new version of Life Safety Code was to be adopted. LD 2012 resolves this issue by allowing the statutes to reference the adopted Life Safety Code directly, ensuring continuity, regulatory clarity, and efficient implementation while maintaining the exact same life safety intent. Secondly, the bill updates language related to rulemaking authority by changing the commissioner's authority from mandatory, a shall, to permissive, a may. The department does not view it necessary to create an entire set of rules for carbon monoxide detectors when Life Safety Code already incorporates comprehensive and regularly updated requirements for construction. Third, LD 2012 updates the requirements for educational facilities by replacing a fixed minimum detector requirement, which is one detector, with compliance directly to Life Safety Code. This ensures that schools and childcare settings meet modern, nationally accepted safety standards rather than an outdated statutory minimum. For example, this building here, by law, would be, if it was an educational facility, would be required to be protected by one carbon monoxide detector. So you can see that that is woefully inadequate if this was a educational facility. Recent carbon monoxide incidents have demonstrated that gas can mitigate well beyond its immediate source and affect large portions of building. In a facility with multiple classrooms, corridors, or occupied areas, a single carbon monoxide detector, while technically meeting the statutory minimum, may not provide timely warning to all occupants. The life safety code accounts for the building size, layout, occupancy to ensure the detector placement provides meaningful coverage and early warning throughout a facility. Finally, the bill clarifies which state and local officials are responsible for administering carbon monoxide detector requirements. This promotes consistency statewide and eliminates uncertainty regarding roles and responsibilities without creating essentially like new enforcement mechanisms. In parallel with this legislation, I have requested an amendment to the Attorney General's Office death investigation protocol to require the Office of the State Fire Marshal to be assigned to investigate all suspected carbon monoxide related deaths. This effort is intended to strengthen data collection, support community education efforts, and provide municipalities across our great state with specialized expertise during these tragic events. In the calendar year 2025, the Office of State Fire Marshal, at the request of local authorities, investigated multiple carbon monoxide incidents statewide, including 4 carbon monoxide related deaths. These incidents underscore the importance of early detection and the need for specialized investigative work beyond the scope of a traditional law enforcement officer. LD 2012 is common sense, prevention focused update that cleans up the statute and aligns Maine law with the adopted life safety terms and strengthens the protections for Maine people. I hope the committee will support LD 2012.
Do we have copies of your testimony?
Yes, ma'am.
Okay. Representative Perkins, do you have any questions?
Yes, thank you, Madam Chairman. Thank you again for being here. Obviously, there's not a huge big changes to existing law, and I'm actually very supportive of this. But I do have one question, something that's kind of confusing me. Why you included LEOs as people that are responsible for enforcement? There's no crime, there's no penalty, there's nothing we could charge under here. And it doesn't seem to be consistent with anything else that you'd find in Part 6 of Title 25. I'm just wondering why LEOs are in there as well.
I think that's an absolutely great question. And the answer to that question is we would never want to restrict our law enforcement officers from enforcing a law.
Well, there's all sorts of laws that there's civil laws, there's all sorts of laws, but police officers specifically deal with criminal law, not, we don't go around and enforce fire extinguishers or other types of things that the fire marshal's office deal with. I mean,
sure.
So would you be okay with taking the LEO portions out of there?
Absolutely.
Okay. That was my question.
We just, when we did the legal review, that was a suggestion that was made because we didn't want to be restrictive on a law enforcement officer's ability to enforce the law.
Okay.
That's the only explanation for that one.
Okay. Yes, Representative Nutting, excuse me.
Thank you, Madam Chair. When you mentioned educational facilities, you listed something in addition to schools, and was that daycare?
Daycares.
Daycare. So currently, does a currently registered daycare facility need a?
That's it.
Okay. So this isn't just about new daycare facilities. This would include a current daycare facility. If the law passed, the rules change, and now instead of one, they need one in each room where children are present.
Not necessarily each room. We would have to look at life safety code because again, that accounts for the specifics in the building. Oftentimes, large buildings are serviced by air handlers. And like, for example, an air handler will service an entire wing of a particular building. And in that case, life safety code allows you to put or install a carbon monoxide detector at the first vent nearest to the actual HVAC unit, so that it would be the first detector essentially that would show a sign or a warning of carbon monoxide poisoning at that point in time. So it's not specific or saying you have to have one in each room or an overbearing financial cost. It would be very specific to the application at hand.
And my second question deals with housing. And this is about new housing units, right? And my question is, what is the current requirement for a single family home. And I'll give you a better example. I certainly don't have a new facility that I live in. I have a really old facility.
Sure.
But there are 4 bedrooms on the top floor.
Mm.
And when we had our fire monitors installed, I believe the electrician who did it said that we only needed 1 on the top floor that did carbon monoxide. We have fire detector in each bedroom. Each bedroom has a closet, but there was only 1 of those rooms that needed a carbon monoxide detector. Is that the current rule? Will that rule change to now require new construction to have?
So the statute, as it relates to single family dwellings, we're not proposing a change. So today, the statute reads, new construction, a person who constructs any of the following shall install or cause to be installed at least 1 detector in each area within or giving access to any bedroom in the new construction of a single family dwelling.
Okay, so any new single family dwelling is going to be under the new.
No, it's currently in statute. So we're not proposing any changes to that section of the statute. The statute already exists to require a carbon monoxide detector in an area within or giving access to a bedroom in the new construction of a single family dwelling. So the fire marshal's office did not propose any changes to the current law as it relates to single family dwellings.
Gotcha. Thank you.
Are there any other questions? Seeing none, thank you very much. Is there anybody else that would like to speak in favor of this legislation?
Senator Bibi Center, Representative Hassenfuss, and members of the Criminal Justice and Public Safety Committee. I am Robbie Feinberg. I'm Director of Communications and Government Relations for the Maine School Management Association. I am testifying on behalf of the Legislative Committee of the Maine School Boards Association in strong support of LD 2012. We believe that as school board members, our #1 responsibility is the health and safety of all of the children in our communities, and we believe that Maine needs to do everything it can to protect our kids. Carbon monoxide poisoning is potentially deadly, and we've unfortunately seen examples in recent years of children who've been hospitalized because of exposure within their own schools and daycares. According to one recent report, one of the most impactful steps we can take to ensure student safety is improving carbon monoxide detection in our schools. While Maine schools are already required to have 1 carbon monoxide detector, as you heard, this bill would ensure effective implementation across our state, and it would also effectively require additional detection in places such as kitchens, portable classrooms, and science labs. By requiring more detection in more areas, LD 2012 would better protect Maine children, school staff members, and help to ease anxiety from parents when they send their kids on the bus in the morning. Our only reservation concerning this bill is the potential cost of implementation. A recent report estimates that if Maine wants to properly upgrade our school building infrastructure, it will cost the state $11 billion over the next 20 years. Many districts are already struggling to keep up with their current school building needs, and we estimate that this bill could add additional expenses totaling thousands of dollars potentially for some districts. Maine school boards are already hearing from their constituents that property taxes are already high, and we worry that this bill may represent an unfunded mandate pushing up costs even further. Our members ask that if your committee does want to advance this bill, we would encourage a funding mechanism such as a state carbon monoxide safety grant program for schools in order to provide local districts with the funds for implementation. Our association would be happy to work with your committee and other stakeholders like the Fire Marshal's Office in order to determine the potential cost of this bill and look at ways to fund this. We believe that protecting our student safety is vital, and we're eager to work with you to make our schools safer. Thanks for your time and consideration. I'm happy to take any questions that you might have.
Thank you very much. Are there any questions? Yes.
I don't
Representative
have a
Nundy.
question, but your offer to provide us with a dollar amount, if the state should choose to fund this, I mean, obviously it's either going to need a mandate preamble or the state's got to pony up the money. If you have some way of determining what that amount of money would be.
Yeah, I think
That would be helpful for our work session, I believe.
we can work on that ourselves. MSMA has a risk safety management center where we go to school, so we can do that. And also I know the DOE has quite a bit of information, so
Perfect.
happy to work on that.
Thank you.
Sure.
Are there other questions? Seeing none, thank you very much.
Thank you.
And we'll look forward to seeing you at the work session. Is there anybody else that would like to speak in favor of this legislation? Welcome.
Good afternoon.
Do you have testimony?
I do not. I am never that prepared. And actually what I have to say is relatively pretty simple. So, Madam Chair, Representative Hasselfuss, and members of the committee, my name is Dan Brooks. I'm the fire chief for the town of Winthrop, but I stand here in front of you as the chair of the Maine Fire Protection Services Commission, which is a 23-member commission that answers to this committee. And we represent pretty much all the different levels of the fire service here in the state of Maine. There are 3 members sitting around this table that are on the commission, as well as the fire marshal, representatives from the fire chiefs, the Maine Federation of Firefighters, the Professional Firefighters of Maine, as well as some other state administrators that have anything to do with the fire service. And basically, I just wanted to emphasize that our commission supports this legislation. Quite frankly, we support the report that just was submitted to you earlier and the legislation that you'll be hearing after this. We, as a commissioner, are supportive of all of this for the greater fire safety of both the public in the state of Maine and the firefighters that serve them. So that's all I really had.
Are there any questions?
Thank you.
Seeing none, thank you. Is there anybody else that would like to speak in favor of this legislation? Is there anybody else online? No. Is there anybody that would like to speak against this legislation? Is there anybody that would like to speak neither for nor against this legislation? Seeing none, we'll close this hearing. Thank you. Okay. We'll schedule this for a work session. Representative Bunker? Would you like to present the next piece of legislation?
That's 2016.
2016?
Again, I wanted to chairs and fellow committee members. Again, I'm Steve Bunker, District 75, Farmington and Chesterville. I'm happy to again also support the Fire Marshal's Office and Department of Public Safety in sponsoring LD 2016 as an act to eliminate the thermal imaging camera program. And I'll be more brief than I was in my last LD itself. This is very simple coming forward, and the Fire Marshal's Office can add to this beyond me. This is the Fire Marshal's Office work in reviewing current statutes and finding things that are outdated or needing either elimination or management oversights to them. And you would see by the language of the LD itself, thermal imaging cameras has some history to it. And when initially started within the state itself, thermal imaging as a type of technology was relatively new in the fire service and gave a new hands-on capacity to be able to see images, even in the dark or smoke-filled conditions, to be able to navigate yourself through a building, but also to detect the thermal imaging where hotspots are within the building themselves to help in their response to extinguishment. And at the time it was initially implemented and funding provided behind it, it provided a great opportunity, particularly for small departments who did not have the local capacity to have this kind of technology available to them in each and every fire department. As technology has advanced and as the years have gone by, this is no longer something new. It's standard practice and standard equipment amongst fire departments around the state themselves, and has been readily available. And since its initiation way back, there's been no further funding behind the program itself. So this statute that creates the imaging camera program is really of no instance or essence within the state itself. And this LD would just simply ask for the elimination of that program and the statute that goes behind it.
Representative Bunker, do you have copies of your testimony?
I do not, but it will be forthcoming in the very near future.
Very good. Okay, thank you.
But I'm sure someone behind me does have detailed testimony.
Okay.
Thank you all.
Well, wait a minute. Are there any questions for Representative Bunker?
I'm sorry.
Apparently, there are no questions either. Oh, yes.
Why, there is. Thank you, Madam Chair. The,
Please.
So if the thermal imaging camera law, I suppose, was in effect and then hasn't been funded, how long has it not been funded for? And if so, if it hasn't been funded and there's no indication of funding it, why not just leave it alone?
I would have to leave it to the state fire marshal to determine what funding has been like since it was initiated. But the need for the funding program itself is no longer there. It's become the standard budgeting practice of most every fire department to have internalized that equipment on their own operation. And this does not anticipate increasing the funding grant program for it because there's frankly not a need. So I would hesitate to ask for a funding program such of this nature with no funds behind it and no necessarily need for departments to ask for it. I think it's met its time.
Very good. Are there any other questions for the representative?
You're very kind.
Seeing none. Is there anybody who would like to speak in favor of this legislation? Sir?
Certainly heard enough from me today.
This is your day here.
Senator Beebe Center, Representative Hassan-Fuss, honorable members of the Criminal Justice and Public Safety Committee. My name is Sean Essler. I'm the State Fire Marshal here to testify in support of LD 2016. This bill repeals thermal imaging camera established in 2001 under Title 25, subsection 2403, a program that was created at a time when thermal imaging equipment was very expensive. I think if I remember correctly, it was $25,000 at one point. Very difficult for departments to achieve. There was limited availability at the time because it was a brand new product and often beyond the financial reach of small departments. The program served an important purpose at its inception by supporting firefighter safety through bulk purchasing and actually interest-free loans to communities. However, over the past two decades, the fire service landscape has changed significantly. Thermal imaging cameras are now widely available from multiple vendors at competitive prices, and departments have access to alternative funding sources. As a result, the statutory program has become outdated and is no longer funded. Repealing the program removes the unnecessary administrative structure while in no way diminishing the importance of thermal imaging technology or the importance of our firefighters. This bill just reflects current market realities, cleans up the statute, and allows the department to focus on higher priority public safety initiatives. One of the messages that I heard very loudly from all the committees that I was involved in last year my first time standing in front of legislature, is if there are laws on the books that need to be eliminated, that are not currently being used or need to be cleaned up, that I was to bring them forward. And this is one of them that is no longer in existence. Today, you can get a thermal imaging camera that snaps to the front of your fire gear for $500. Okay? A FLIR camera, NFPA compliant, could be $5,000 versus the $25,000 it once was. And of course, we see cameras that are still very high in technology, somewhere around $10,000 to $15,000. But 10 to 15, the average camera today of $5,000 is nothing compared to the $25,000 price tag 20 years ago. So again, this is just simply a cleanup bill, and my recommendation is it's repealed. Thank you.
Are there any questions? Seeing none? Thank you very much. Is there anyone who would like to speak in favor of this bill? Phew. Is there anybody who would like to speak against this bill? Is there anybody who would like to speak? I'm sorry, is there anybody online? Is there anybody who would like to speak neither for nor against this bill? Would it make sense to go into a work session on this bill? Okay, is there a second? Okay, all those in favor? We're voting. Good timing.
Okay, so let's take a quick straw poll vote here. So we have LD 2016. This is an act to eliminate the thermal imaging camera program. It's voted into a work session. Is there a motion on this bill?
Yep. Senator Searway,
Okay. I make a motion to.
Mike.
Microphone.
I make a motion for this bill to be voted no longer.
We first got to move into, we already voted.
We did.
Yeah, we already voted to go
We
into work
voted
session.
work
Yeah,
session.
so no longer needed.
Okay, ought to pass,
Yeah.
repeal it. Okay.
Not bad.
Yes, Representative.
I'll second it.
Okay. Any discussion? All those in favor?
Give Bernice a second. Hang on.
Yeah.
Okay.
If Bernice wants to
Okay,
take
wait
a
a
straw
second.
poll vote.
Sorry about that. Sorry.
And we said in training, this year I'm supposed to repeat your votes back to you.
Okay.
So, Representative Hassenfuss,
Yes.
Representative Nutting,
Yes.
Senator Searway.
Yes.
Oh, I'm not. Representative Abdi,
Yes.
Representative Perkins.
Aye.
I know, I realize I
Yes.
contradicted myself. So Representative Abdi says yes. Representative Perkins
Aye.
says yes. Representative Ardell,
Aye.
Representative Ardell says aye. Representative Butler.
Representative Bunker says yes.
That'll throw me. Representative LaJoy.
Yes.
Representative LaJoy says yes. Okay. Senator Beebe Center.
Yes.
All right. And the motion was not to.
Yes.
We have 1, 2, 3, 4, 9 in favor of the motion ought to pass and 4 absent.
Thanks.
We did it. My understanding is that that's our entire agenda. Are we ready to?
Motion to adjourn.
Is there a second? Second.
So it's.
Thank you very much. Thank you. We're done.
Back tomorrow. See you, it's something Yeah, I didn't know if there was like one issue.
Thank you.
Yep.